Uh, kind indulgence of my lord. My lord, kindly grant me leave to move one unlisted AB this afternoon. The reason is that on 29th, CWC London has filed an FIR, so moto FIR, before London SP, and then it was sent to the Waka police station. Now, on 31st, on 29, the Waka police station visited my home. Then again on 31st, 31st, they visited my home at Yazeli Milot. Then again on 3rd, they visited my home. But I asked for the copy of the FIR, they are not giving. Or even I have asked for the case number. The Young Bar Association 2016, my lord is aware. It is mandatory for the police to disclose the case number and the reason why you are being looked out for. And also, my lord, secondly, no notice was issued. So I'm apprehending my arrest.
Offense involved is?
I don't know, my lord. Only they said that there was the girl which they projected is a minor, but it is according to their according to the Aadhaar card, it is 18 years, my lord. And secondly, my lord, the allegation is on the social media, my lord, is the child trafficking.
Child.
So kindly, my lord.
So in the afternoon, there will be
Afternoon, my lord.
No. Election petition, the trial will be there, so it will be difficult.
My lord.
Tomorrow.
My lord, kindly, but there is urgency.
It will take time. The election.
No, my lord, it will not take time. There is an urgency.
The election petition will take time.
Election petition. My lord, possibly like at 2 o'clock, my lord, already filed, my lord. Possibly, kindly this liberty, my lord, personal liberty of a person. My lord, kindly take over. Thank you.
So let's go. I'd like to mention for item number 5 to withdraw the same as per instruction from my client. Item number 5.
Criminal petition.
Yes, Lord.
Mr.
G.
Phukan, Land Counsel for the petitioner, submits wants to withdraw this criminal petition with liberty to file a fresh after May. Why you want to withdraw?
As per instruction from my client, Lord.
Okay. Submits that he, Mr. So-and-so, submits that he has an instruction to withdraw this criminal petition with liberty to file a fresh.
No liberty may be given, my lord.
No, what is the reason? Just
They informed that they did not the requirement documents as Zimma for.
okay. The criminal petition is dismissed as withdrawn. Okay.
Yes. Obliged.
Obliged.
May it please, my lordship. In item number 18, we would like to seek permission to withdraw the appeal. The appellant has expired and the legal heirs do not wish to pursue the matter any further.
You want to withdraw?
Yes.
Okay. Miss
Renium Takam, R Takam.
Atava, Land Counsel for the appellant, submits that he has an instruction to withdraw this appeal. Who is for other side is present? No.
No.
Okay. Okay, the prayer is allowed. This appeal is dismissed on as withdrawn. Okay.
Your lordship, I would like to bring your attention to item number 17, which is a connected matter to item number 18 that we are withdrawing.
Same, similar prayer.
But no one is appearing from their side. So that is their counter appeal.
Counter appeal. No, let it be done. Let it remain as.
Okay, thank you.
You're for respondent here.
Yeah, for respondent in item 17.
Okay, let it remain there.
Much obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 3, Lordship. Item number 4, admission. Lordship, this is regarding bail cancellation. I am for the respondent. So I have informed the counsel for the petitioners. Let the matter be listed after 3 weeks, Lordship.
After 3 weeks?
Yes, Lordship.
Record was called for here.
Record, no, Lordship.
Let us see. I think I need to call for the record here. Without record, it will be difficult.
Yes, Lordship.
Okay. Mr. Our Learning Counsel for the petitioner is present. Mhm. And,
4.
submits that record was not called for in this case. It appears that the record, a trial court record would be necessary for adjudication of this. Criminal application, accordingly called for the trial court record. Not trial court record, it's case diary, I think.
Charge is already submitted, Lordship.
Okay, trial court record.
Trial court record.
Okay, trial court record. Okay. He also prays for listing this matter on
After 3 weeks, Lordship.
3 weeks. After 3 weeks, prayer allowed. List this matter after 3 weeks. Okay.
Lordship. Lordship, and I beg to mention item number 7. Lordship, here liberty was granted to the petitioner to approach the learned trial court. So petitioner seeking further 3 weeks time, Lordship. In the meantime, they will approach.
Okay, Mr. Lauren Land Counsel for the petitioner. Seek further 3 weeks time to approach the trial court.
Yes, Lordship.
Okay.
Liberty was given, Lordship.
Okay, submitted, a liberty was given to the petitioner to approach the trial court. Which he, not yet.
Not
approach.
yet, Lordship.
Approach for what?
Approach regarding issuance of non-bailable warrant, Lordship.
Okay,
Approach here for cancellation, but this honorable. court
okay,
granted
then,
it.
okay, Lauren Land Counsel for the petitioner sought for further 3 weeks time to approach the trial court. Prayer allowed, list this matter after 3 weeks.
Yep.
Okay.
Deeply Lordship.
Mayor Lordship,
Mm.
I would like to mention item number 3, Lordship. Conducting counsel is out of station. And also item number 3. And
Item 3.
yes, Lordship. And I have taken consent with parties.
Item number 3,
Yes, Lordship. 3.
it was mentioned. 3. Okay, noted.
Yes.
Okay. What do you want?
Matter may be fixed on after next 2 week.
You are for?
I'm from
For the petitioner.
yes, Lordship.
Who is for the respondent? Okay, state. Mr.
Uh,
You are
K-
Mr.
K. Carlo.
Learning Counsel for the petitioner prays for adjournment of the matter for after
After 2 weeks, Lordship.
for 2 weeks. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
Well, may I mention? In fact, you also may allow to withdraw one bail application. In fact, it was filed. We want to withdraw that bail application IA 122 of 2025. It's not listed today, but we want to mention that might be listed, and we want to withdraw. Then we want to file fresh.
Okay.
We want to main matter is coming up on 8, so we want to withdraw and file fresh. Obliged.
Item number 1.
May I please, madam?
Yes.
Madam, by way of this application, madam, the petitioner is seeking some protection from this honorable court in respect of the case registered in Itanagar Police Station, my lord. In this case, my lord, the petitioner is not named in the FIR, or there is no chain of circumstances linking the petitioner in the instant case. But however, my lord, the investigating officer has been constantly calling the wife of the petitioner and directing her to bring the petitioner before the police station. Therefore, I have a genuine apprehension, my lord. My personal liberty is at the stake, and I doubt, my lord, I will be entangled in this case, my lord, illegally. If my lord may kindly have page number 22, that is the FIR, my lord. My lord will find the type copy at page number 26, my lord. If I may read.
Yes. So your name is not there.
Not there, my lord.
2 persons arrested.
2 persons has been arrested, my lord. And I have a genuine apprehension, my lord, that
I would be dragged into this case, my lord, for a simple reason that one of the arrested person is my relative, my lord. Only that, my
Are you claiming that you are innocent?
lord. My lord,
Where?
I'm nowhere connected in this case, my lord.
Where have you stated?
My lord, in paragraph. My lord, may kindly have para 8.
Hmm. Hmm. Where have you stated that you are innocent
Lord, I have not
and not connected
specifically
with?
stated that I'm innocent, but I'm nowhere connected in this case, my lord.
Where have you stated?
My lord, may kindly have para 8, my lord.
Yes, where?
Willingness
Can
to
you read?
appear, and then, my lord,
Read the relevant portion.
my lord. My lord, may kindly have para 6, my lord.
Yes.
The petitioner most respectfully submits that notwithstanding the aforesaid undisputed and objectively verifiable facts, the conduct of the police authorities has caused serious anxiety and distress to the petitioner and his family. The investigating agency has on repeated occasions been contacting the petitioner's wife and calling upon her to secure the petitioner's appearance before the police, solely on the fragile and untenable premise that one of the arrested alleged accused happens to be distantly related to him. Such repeated interference in the absence of any incriminating material or lawful basis has created a real, imminent, and reasonable apprehension in the mind of the petitioner that he may be subjected to arrest at any moment, not as a consequence of evidence or investigation, but due to mere suspicion and association. More so, in absence of any material taking recourse to any cause of action, in these circumstances would be arbitrary, unjustified, and violative of certain principle of so and so, as neither familiar relationship nor conjecture can substitute legally admissible evidence or justify deprivation of personal liberty.
No, see, there was an incident. My query is only just where have you stated that you are innocent, you are not connected with?
Specifically not mentioned in the paragraph, but
Then,
since I have been receiving continuous calls, my lord, that is where.
then
my
why should you worry?
My lord,
Then why should you worry
my lord,
if you are not at all connected with?
but I have been receiving calls from the police officers, my lord.
Then tell the
Stating,
police. Tell the
stating that,
police.
my lord, since one of the accused person is my relative.
So that is why, how can the police arrest
My lord.
you only because your relative, one of the relative is involved in the
At
case?
least, my lord, I'm expecting a notice from the police also. If
No,
there's nothing,
but the police is not issuing probably notice because you are not involved. Why should you worry about?
but the reason is that I have a genuine apprehension that I have been constantly receiving a call from the officers, my lord.
No, where? Where have you stated that you have received the
I
call?
have stated in para 6 also, my lord.
The police is
Yes.
calling through your wife.
Through my wife, my lord.
No courage to call you.
But
Who
I've
are you
been
otherwise?
harassing my wife continuously, constantly, my lord. And directing her to
Lodge complaint against police.
That-
Wife should lodge complaint against police. Why should the police harass you?
maybe one or other reason, my lord. I'm not aware of the reason. But I have been calling my
But
wife.
you are also not saying you are innocent or not involved in the incident. If you are involved and this is you see, you have grievous. This is a grievous hurt to the officers,
My lord,
director.
the FIR says that there were two assailants and two persons were already arrested. And one of the
That is
arrested
why
person
should
is
you
my
worry?
relative.
Why should you worry?
I have a genuine apprehension since the police has been calling my wife continuously, my lord, and asking me to appear before the police station. My lord, till the next date, otherwise, my lord, the CD will speak for itself, my lord.
We'll call
And
for
I'm
the
also
CD.
taking the plea
We'll
of
call for the
alibi.
CD. If there is nothing,
My lord.
why should you worry? We'll call for the CD.
That is the worry, my lord. That is the worry, since police are calling continuously, my lord.
We'll see the CD.
My lord, CD will, on the next date, my, if there's anything against me, my lord, CD will speak for itself, my lord. Till the next date, my lord, I may be protected, my lord. I'm ready to cooperate with the investigating officer. Till the next date.
If your relative is involved, you don't have to cooperate with the police also, it appears, if you are
They
not
have been
involved.
calling
But
me-
you are not saying that you are innocent or you are not involved,
I'm nowhere involved in this case, in fact, my lord. But
not showing anything.
I'm also seeking the plea of
There is no
alibi
reason
also.
for your apprehension, it appears.
My lord, on the date of the incident, my lord, I was at Kimin, and I'm a responsible person.
That is why I'm saying, you saw these photographs that you were
My-
on that day, you were, but the incident occurred not in the daytime, it was at
in the night,
9:30, 9:50 p.m.
9:50.
In the daytime, you may be in Delhi, but then it occurred in evening.
But the allegation is that there were two assailants and those two assailants were already arrested.
Are you saying that you are not those two assailants?
Not
Where?
at all. Not at all, madam.
No, where have you stated?
I have, kindly just give me a minute. My lord, they kindly have para 5. By way of para 5, I'm trying to demonstrate that I was at Kimin on that day. And then
What have you stated here in para 5?
para 5, I have stated that, if I may read, my lord,
Hmm?
if I may read, my lord. On the date and time of the alleged occurrence on 1/12/2025, he was publicly present at
Yes, you are claiming alibi.
alibi, my lord.
Okay. But then you are not saying, what I'm saying is you are not saying that you are not connected with or not involved with or innocent. Where have you stated?
That paragraph is not there, my lord.
So even if you are claiming in alibi also,
My lord.
if you were present at Kim in Delhi, wherever maybe, but then if you are involved in a,
But my lord, the allegation, if my lord may kindly see the FIR, the allegation is there were two assailants. And basing on that, that FIR, those two assailants were arrested. Now, my apprehension is that since one of the arrested person is my relative, for a simple reason that he is my relative, I have been constantly receiving calls. That is only my genuine apprehension, my lord.
yes,
Till the next state, my lord.
yes.
Lordship, CD may be called Lordship, so that otherwise Lordship, I'll take instruction Lordship by telephonically whether he was called or not Lordship. That I can do also Lordship.
यहीं पे रहने देना बाद में सब क्लियर कर दूंगा
Which PPS case?
Itanagar police station.
कोर्ट काउंसलर से पूछा
I'll take, my lord. Imping order, start from page 16, my lord. On relevance, my lord, I'll take, my lord. Page 49, my lord, find it, page 49, relevant portion, my lord. Yes, page 49, paragraph 127, my lord. May I?
Yes.
Para 127, start from para 127, my lord. The perusal of the case record pattern reveals that the Court of Learned Civil Judge, Junior Division, Palin passed order in present case from so and so honor, but no reason has been mentioned as to why the court took up the case. Even though the subject matter and territorial jurisdiction falls within the court at 0, Lower Subansiri district, neither has the Court of Learned Civil Judge, Senior Division 0, given any reason in the order dated so and so regarding the circumstances that compel the court to transfer the case to the Court of Learned Civil Judge, Junior Division, Palin. It is also quite obvious that both the counsel for the parties did not protest to the transfer of the case. Had they protest, certainly this would have been reflected in the order dated so and so, my lord.
No, see, under the circumstances,
Yes.
you should have annexed that order 2211.
Yes, my lord. Issue,
No, 2212, 2021.
my lord.
Why it was transferred? Only for recording the evidence or something else to
No,
dispose of the
evidence,
matter?
all the evidence were taken before the senior division. Only final argument was took place at junior division. my lord.
Then
My lord,
how the appeal lies before the senior division then if the senior division has taken up the matter?
That's why I am, therefore I am before this court, my lord. My three substantial questions here is that, my lord,
Okay.
senior divisions,
Okay.
appellate court, past appellate court should not have dismissed the appeal without drawing any degree. Though past appellate court simply dismissed the decree and order passed by the original suit, junior divisions without drawing any decree, my lord. And that's territorial jurisdiction. When it was transferred to the junior divisions, no party has raised any objections regarding the territorial jurisdiction, my lord. As per section 21 of the CPC says, if no party raised the territorial jurisdictions of the court, that cannot be, will become the stoffel, my lord. That right has to be waived, my lord.
I think so is the party.
So, my lord, kindly see, I have here. My lord, may kindly see page 10, where I have framed substantial question involved in this case, my lord. Simply, past appellate court cannot simply dismiss the order. If past appellate court simply dismissing the case means case has not been resolved, my lord. Past appellate could have remanded back to the court who have the jurisdictions and also could have drawn the decree
Okay, we'll issue notice and call for record.
my lord, as per section 100,
Hmm.
notice should go after framing this substantial question of law.
Substantial question of law.
Yes, my lord.
At the time of admission next act, we'll admit on the to decide this substantial question.
Anyway, no, that's all.
Okay.
Okay. Otherwise, my lord, I have IA. Otherwise, the opposite party will after taking an advantage of this dismissal order, they are, my lord,
What is this about?
about the land, my lord.
Hmm.
Plot of land located at Hapoli Siro, my lord.
Apoli?
Hapoli Siro.
It's not Apoli Siro. Apollo and Zero is different.
Difference, no, zero, my lord, zero.
Okay.
And there are dispute between this party, then plaintiff approached this present respondent, approached the civil court, And-
Say senior division.
senior division,
Initially, it was filed before the senior division.
senior division, and all the evidence were taken before the senior division. Then during the final argument, it transferred to the junior division.
Only at the
Arguments,
final argument.
only final arguments, my lord. Then final argument was heard without objecting the territorial jurisdictions of the court. Then it was dismissed, the plaintiff with cost, my lord. Against that order, present respondent plaintiff approached the senior division as an appeal, my lord, past appeal, and past appellate court, senior division, what they did, simply dismiss the suit, my lord, and dismiss the judgment and decree passed by the junior division.
Saying it doesn't have, the junior division doesn't have the jurisdiction.
Territorial jurisdictions, yes. So otherwise, section 21 is very clear, my lord. My lord, may kindly see the section 21 of the CPC, my lord.
What it says?
Yes, my lord, I'll take my lord. Party has to raise the territorial objection regarding the territorial jurisdiction at first instance, my lord.
Yes.
Page, my
No,
section,
that is why I'm saying,
Yes.
what was the order? You should have annexed the order, say the order itself.
so the order, my because issue involved here is, my lord. From judgment, it is clear, simply that says territorial junior.
Because we do not know on the prayer of the party, on the prayer of the petition, a plaintiff or respondent, or for because of the judge was.
One thing is, my lord, clear, civil,
So many things.
yes, my lord.
So we,
Civil judge, senior division cannot transfer even.
no, that is why. What was the reason
Reason is not one, but even impugn order itself say,
for transfer? It actually.
no reason is given.
A file
Yes, my lord. Kindly see, my lord,
for the High Court.
section 21, my lord, objection to the jurisdictions. No objection as to the place of suing shall be allowed by any appellate or revision court unless such objections taken in the court of past instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequence failure of justice, my lord. So appellate court should not have decided that the jurisdictions, my lord, since the party did not raise any objections.
No, records would speak. We need to call record in this case. And then thereafter,
No, at this system,
Acting on that.
substantial question of flow may be framed, my lord. They will, opposite will argue.
let the party appear and will admit on the above substantial question to decide the above substantial question raised by you, okay?
Otherwise, the impugn judgment is very clear, my lord. That's impugn judgment said they do not have the territorial jurisdictions. Therefore, they dismiss and set aside the. As per order 41, rule 23 also says, well, it should be remanded back.
Yes.
It could have, appellate court could have remanded back the matter to the
Right.
court. So anyway, then let's issue the notice, call for a record.
Mr. Kedari, land counsel for the appellant. Para. This is an appeal filed under section 100 of the Code of Civil Procedure. And order 41 of the Code of Civil Procedure against a judgment and order dated 25/9/2025, passed by the Lanet Civil Judge Senior Division, Lower Subansiri District 0, in title Appeal number 01/2023, whereby the judgment and decree dated 20/04/2022, passed in title suit number 02/2015, passed by the Lanet Trial Court, Civil Judge Senior Junior within bracket Junior Division has been quashed and set aside for want of jurisdiction. Staka. Issue notice. Call for the trial court record. The petitioner, the appellant shall take steps upon the respondent by a speed post with AD within a week from today. Staka. List is matter after 4 weeks.
And yeah, my lord, one thing may be clarified, my lord. Next day, substantial question of law will be formulated, my lord.
Okay. They automatically let them appear.
Otherwise,
So
okay, then, my lord.
because the second appeal is to be admitted on the to decide a substantial question
Yes, otherwise, my lord,
of law.
as per the section 100,
Hmm.
notice is to go after formulating the substantial question of law, my lord. Because
Let us see, because you have not annexed the entire document also. Let us see if the substantial question you have raised, how many questions? Substantial question of law 4.
so only
Let us see the records.
so anyway, my lord.
Hmm.
And my lord, IA is there, my lord, for both parties, my lord, status quo be maintained, my lord. So it will nowhere will affect either of the party, my lord. Status quo since only status quo, my lord.
Of course, substantial law, question of law is there, but then prima facie, it appears that the judicial magistrate, the civil judge junior division doesn't have a jurisdiction.
Exactly, my lord. Doesn't have the jurisdiction, but that part is to be raised by the parties, my lord. In past instance, my lord, if they didn't raise that objection, my lord, in appeal or revision court, they cannot, my lord. Law is clear, my lord. They cannot, my lord. And their constitutional bench, my lord, 5 bench judgment is also there, my lord. So, if the past appellate court has wrongly decided the and dismiss and set aside quash and set aside the degree and judgment, my lord, without drawing any, though they have determined all the issues, my lord. Though the appellate court decided all the issues, my lord.
Lane is under whose possession at the moment?
That as per the original decree, my lord, it is with the respondent appellants, my lord, present appellants. And after dismissing, set aside the
When it was dismissed? 24.
Yes, my lord.
Only after dismissal.
Appeal by appeal set aside and quash.
9/25 September.
Yes, my lord. And nowhere, my lord, therefore, my lord.
It was dismissed on 9 September.
Yes, 9 September.
You have filed on time.
Yes, on time, my lord. Last day, my lord. So, my lord, simply status quo, my lord.
Well, where have you stated that it was
Yes,
with
ma'am.
the appellant and then after dismissal, it was taken over by?
No, not taken over, my lord. Not taken over by the, they are trying, my lord.
Now, my question is the lane at the moment, the lane question is under whose position?
Under my position, my lord. At the depot also and presence also, my lord. They are disturbing my position, my lord. So therefore, decree was passed in my favor, my lord, by
Yeah,
dismissing the.
Will issue notice here also because
No, at least
They-
so that will maintain the peace also, my lord. It will premi pisai, my lord. Past appellate court, my lord. Judgment decree passed by the past appellate court, my lord, is wrong, my lord, in law, my lord.
Okay, after that, no? Same thing. The appellant has also filed application under Order 41, Rule 5 of the Code of Civil Procedure, read with Section 151 of the Code of Civil Procedure 1908, seeking stay of the judgment and order dated 25/9/2025, passed by the Land Civil Judge Senior Division 0 in title appeal number 01/2023. Upon hearing the land counsel for the appellant and on consideration of the averment made, comma, it is provided that in the meantime, the status quo over the, is it a lane or what, plot of land?
Plot of
Status
land.
over the plot of land at land shall be maintained by the parties till the next returnable date. Okay.
Published. Published.
Item number 8.
Yes.
Eight. Legal aid appoint हुआ नहीं अभी तक। हो गया?
Who is for the petitioner?
Seems to be absent today, Your Lordship.
Bori is for respondent number,
Legal aid,
or legal aid counsel.
yes.
For respondent number 2 and 3. Are you filing objection?
Not filing only verbal.
Hmm?
Oral.
Or not appears on behalf of the petitioner. However, Mr. Gini, Learned Additional PP, and Mr. U. Bori, Learned Legal Aid Counsel for the respondent number 2 and 3 are present. In absence of the counsel for the petitioner, the matter stand adjourned. List is matter after 2 weeks.
Declare.
Whether, okay, okay.
Item number 9.
2 weeks.
Your Lordship.
Hmm.
Is in bail application. Today is fixed for hearing, Lordship, and CD. And today is 67 days intermediate quantity.
Hmm?
Today is 67 days intermediate quantity in the.
Charge sheet filed well within time, within 55 days, my lord. Charge sheet has been filed and
Okay.
it's before the trial court, my lord.
Okay.
So now the question of default bail doesn't come, my lord.
Is a default bail. Sorry, default bail.
No, Lordship, I don't know about whether search sheet was filed or not.
Okay.
But
Now,
it is
now then,
67 days. And co-accused,
charge sheet already filed within time.
co-accused already granted bail by
Status report, my lord.
Special NDPS Lordship Papum Pare. Co-accused Mr. Yaru Tachu.
The first line only, my lord, the status is And my lord, perhaps they have not approached the trial special court prior to approaching this honorable court, my lord.
It's a
because-
regular bail. Have you filed a regular bail before the trial court?
No, Lordship.
Why you have directly come before this court then? Then now the case has already been charge sheeted.
Let him approach the trial court, my lord. Since the charge sheet has been filed, now the trial court is in the best position to ascertain whether the judicial custody is required or not, my lord, for the trial.
The early case diary was called for.
Yes, my lord.
Yes,
My lord,
Now, since the case has already been charge sheeted,
yes, my lord, will find in the first page itself, my lord, the last paragraph, my lord.
submitted in the charge sheet on 25.
Yes, within 55 days, my lord,
Okay.
not 60 days.
Then we'll have to call for the case, case record then in that case if you have to.
Yes, my lord. Otherwise, my lord, the best option would be, my lord, to approach the trial court because they have never approached the trial court, my lord.
You have
Directly approach this honorable court.
The case has now been charge sheeted. You approach the trial court.
Yes, Lordship.
Then if agree before this court, my lord.
Mr. Piete, then additional PP submits that the case has already been charge sheeted against the accused on 25/12/2025 and is now pending for trial before the special judge UPIA.
EPS.
Yes, my lord, the special court.
DPS UPIA staff. In view of the above, Mr. G. Pukan, Land Counsel for the petitioner, press for allowing him to withdraw this bail application with liberty to file a fresh bail application before the trial court. The prayer is allowed. This bail application is dismissed as withdrawn with liberty to approach the trial court. Okay.
My lord, CD may be returned. That may be reflected, my lord.
Return the yes. This is CD.
Yes, my lord.
Okay. Return the CD. Okay.
Obliged.
Obviously.
Item number 10,
My lord, this is a bail, lordship. The rejection, basically the ground which I have taken in this bail application, that the ground of arrest was not communicated to the accused person. Which
ground was not communicated.
Yes. In my bail application, Annexure 3, page 22 is the arrest memo. Now, reason at column number 15, reason/ground of arrest, which has been mentioned from subclause from A to D. The only reasons they have mentioned, but no ground was assigned. In this regard, your lordship has trial court record has also been called for. Basically, I'm relying on the judgment passed by the Honorable Supreme Court, as well as your lordship's one judgment of Imphal bench is also with me, wherein the ground of arrest was not mentioned, nor the communicated to the accused person. That has to be communicated in writing. That was also not communicated.
Yes, Ms. Jenny, whether it was.
Your Lordship, no, Your Lordship will see on many occasions, I have put my argument on this, that the trial has started, Your Lordship. The deposition of witnesses has also been taken, Your Lordship.
Okay.
Now, when it comes to the ground of arrest, Your Lordship, that is only till the stage of remand during investigation, Your Lordship. Subsequent to when the trial starts, this ground cannot be taken for seeking bail, Your Lordship. That was very clear in a recent case, Your Lordship. If Your Lordship just fix this matter, otherwise my learned learned counsel El Hagi was appearing. She seems to be busy, Your Lordship.
Okay, you are for?
I'm for victim.
Okay, victim.
When the last occasion, victim was appeared before the London Session Court, and the statement was given, but there is no allegation against the accused person. As such,
You are for victim.
yes, as such, the London Session Judge.
You have no objection.
Yes, London Session Judge not recorded the statement of the victim, and
Not recorded.
yes, because
Or recorded or not recorded? You have just said, I heard.
but she given the statement before the London Session Judge, but the statement was not recorded as because there is no any incriminating material was stated by the victim against the accused person as such.
Whether this is case record? Trial court
Lordship,
record?
if Your Lordship,
Whether the victims
if Your Lordship,
deposition is also there?
in that case, if Your Lordship take up this matter after some time, Your Lordship, since the other ground, the ground of arrest, I have already made my submission, Your Lordship, with regard to Mihir Shah cases, Your Lordship. Other part, that since the victim is also not objecting, I'll just have to see the record in that case, Your
Okay,
Lordship.
just see the record and especially her deposition.
Yes, Your Lordship.
Whether.
No,
After some
victim's statement has not recorded. The informant statement was recorded.
Hmm?
On the last date, before the landed trial court, two witnesses were summoned, informant and victim.
Okay.
Both were appeared. Informant statement was recorded, but the victim statement was not recorded.
That victims.
Just see.
Victims.
Matter number 11.
Hello, sir. Service is completed. Matter may be fixed for admission hearing.
Okay. Mr. You are Mr.
B. Sibo.
Land counsel for the petitioner is present and submits that the service is complete. The matter may be listed for admission hearing. Ms. El Hage is also present as pro, list this matter. And since the parties are duly represented, let this matter be listed after 3 weeks for admission hearing. Okay.
Like Joseph.
Matter number 12.
No, just because it will take time. We'll complete the other matter.
My lord.
I think not so many matter.
My lord.
Okay.
All right.
Now this is 12. 12 and other than election petition, election petition will take up as the last item.
Matter number 13.
Please, Lordship.
Yes.
Item 13.
Hmm.
My lord, service report not yet returned as per registration law.
Mr. M. Bojilan, counsel for the petitioner is present. Service upon the respondent number.
Sole respondent.
Sole respondent is still awaited. In view of the above, let this matter be listed after 3 weeks.
Yes, my lord.
Okay.
There is order in IA 274.
What
That
is
is
that?
stay order of the impugned order.
What is the impugned order?
Impugned order is stay the impugned order. That was order passed by District Lanet Additional District System Judge Basa.
Okay. Mr. Mboje, Lana Council for the applicant, staff, huh? In IA, huh? List is matter along with the main appeal after 3 weeks. In the meantime, the interim order passed earlier shall continue till the next date of listing. Okay.
Yes. My Lord, LCR was also called for, but that
Okay, it's there. But then no one is appearing on behalf of the other side. So let them appear first.
yes.
Okay.
I will.
Item number 14,
14 is also
election.
is election petition.
Lordship.
So other than 14,
Lordship. Item number 15,
we'll complete the other matter.
Lordship.
May I please, my lord?
Yeah.
My lord, after filing of this case, the learned ESC Itanagar has recalled the impugned order dated 30 July 2025, and hence the present case is become in practice. So I may be allowed to withdraw, my lord.
Mr.
Nawam Talin and Talin.
And Talin, Learning Council for the petitioner, submit that. What is the submit? They have recalled the order.
Yes.
After filing of, so and so submits that after filing of this criminal petition, the impugned order dated 30/7/2025 has been recalled by whom?
ESC Itanagar.
By the extra assistant commissioner. And as such, this matter has become infructuous. Therefore, he has an instruction to withdraw this criminal petition, to which Ms. El Hagelan Council, Land Additional PP has no objection in view of the above. The prayer, this criminal petition is dismissed on becoming infructuous. Okay.
Obliged.
Item number 16,
None appears on behalf of the parties on call. Matter stand adjourned. List is after 3 weeks. Okay.
item number 17,
No.
Actually, the order, but somebody made mention, we don't recall.
Yes, yes.
Lordship.
No.
Item 18 is disposed.
No,
Dispose of
18
this one.
disposed, and then no one appear on for 17 because it was against him. So that is why. None appear on behalf of the appellant on call. List is matter after. Bori is not there. Boko. After a week, okay.
Item number 19 and
After 2
20.
weeks, huh? Okay.
Item number 19 and 20.
So these matters are fixed for hearing, my lord.
Fixed for hearing.
Yes. Whether it will be possible, my lord, I have been told election case is there.
Yes, election case is there.
Not possible then, my lord.
This matter is likely to take some time, at least 5-6 hours.
Okay.
So I think if an understanding is arrived at that the matter will be fixed on a particular day, and if it spills over, it can continue the next day. And a
Okay.
convenient date may be fixed.
Okay, then give the date.
9th of
9th of
February, I
February.
think.
9 February, probably we have a lot of cases, it appears,
Ah.
before the DB also. And then that,
No, February to more or less khali ase.
16 weeks more, I think.
Huh? Huh?
Weeks from 16th, I'll be not there.
9 February,
23rd
before this
February.
court also, some
23rd
matter.
ত মই আহিব লাগিব।
No, I am 9th of February, my lord.
So 9th of February, probably the other matter, division matter also probably.
2 division matter.
And then I have seen one single bench matter also on 9th, it was fixed.
Okay.
And where the AG is to
In that
appear.
case, হেৰি কৰিলো। I have to again come back on 23rd February. So 23rd February.
If it is likely to take more days, then it's 23rd and 24th, say 23rd.
2 days can be kept for this.
At least the time.
24th, 25th, let it be, my lord. We are having some difficulty. 24th, 25th, can it be?
Okay,
24th.
we'll say 24th.
24th is fine.
Okay.
My lord, may I just point out
And
one aspect of the
হেৰি
matter very
records
important.
খিনি কল কৰা আছে। Records of
Formal paper কৰা নাই। আমি informally এটা বনাই লৈছো।
No, more.
My lord, in this case, my lord, we moved an application for stay of the execution. My lord, your lordship will kindly find from the order dated 7/5/2025. Last order 17/11, my lord.
20.
Yes. Yes, 7/5 or 7, okay. There is a stay.
My lord,
Okay. So what is this order?
my lord, the execution proceeding is pending, my lord.
Oh.
Now, in the execution proceeding, we file an application intimating that, my lord, there is an order of stay. Now, if your lordship will kindly, may I just read, my lord. Third paragraph, your lordship. Mr. Ahmad, the counsel appearing on behalf of the deposition of so and so and so stated that since the appeal against the execution petition is pending before the Honorable High Court and is fixed on ITNA, he has prayed for that as per the order dated so and so. It has been mentioned that the interim order passed earlier shall continue till the next date of listing. Next is important. Mr. Bomian Ori, the learned counsel for the degree holder, submitted that there is no any interim order passed by the Honorable Guwahati Itanagar bench. He further submitted that as per the referred order by the applicant, there was no stay of any order passed. It is pertinent to mention herein that though the execution case of this court has been stayed by the Honorable Guwahati High Court, still judgment letter number 2, despite being directed, has not filed any reply on the excuse that the execution case has been stayed. Mr. Bowman Ori, learned counsel for the decree holder, submitted that this is the fifth time the judgment dated 2 is seeking the adjournment without filing reply. Therefore, as prayed by the learned counsel for the decree holder, the court issues a notice to the judgment debtor. Number 2, that is chairman cum managing director, Lower New Colony, Assam, under so and so, as to why warrant of arrest should not be arrested against him in consequences of filing of execution of degree by the judgment debtor. Now, matter is fixed, my lord, on 3rd. Now, my lord, your lordship will kindly see from 7/5/2025, my lord. My lord, the your last order is also very clear. My lord, when we moved the matter, my lord, on 7th, the stay application, then, my lord, this honorable court was about to pass the order of stay, my lord. In then, my lord, my friend Mr. Pathak made a submission. Your lordship will kindly file the order dated 7/5/2025. There is an undertaking by him, that they will not proceed with the execution. Thereafter, a stay order has been passed, on subsequent orders. On 7/5, they have given an undertaking before this honorable court that they will not pursue the execution petition.
Yes.
Matter was pending. It continued. Somehow, it's not that, we sought adjournment and all that, and, trying to delay the matter. But matter could not be taken up. Matter has been adjourned from time to time. Thereafter, my lord will find that there is a specific order by this honorable court saying that the earlier interim order will continue. On the last occasion also, my lord has passed on 17/11. Last order is of 17/11, my lord. The first order was 7/5/2025.
Yes.
My lord got it, my lord.
So this interim order is only to not to proceed with that they will not pursue with the execution.
Not pursue on 7/5, that was they have given an undertaking, my lord. Thereafter, my lord, your lordship will kindly see, thereafter the orders are passed on 16/6/2025 by my lord, my lord. Second part, in the meantime, the undertaking given by Mr. Pathak, Learned Counsel for the response so and so continue till then. Then, my lord, next order, 23/7. Fourth paragraph. In the meantime, the undertaking given by Mr. Pathak, Learned Counsel for the respondent so and so, and extended so and so, shall continue till then. The next order is 20th of August. Third paragraph. In view of the aforesaid order dated so and so, subsequent extension so and so, agreed by the Learned Counsel for the party, the order dated now is extended till 23/9. Next. In the meantime, the execution case pending before the district judge Alo West Siang, an affidavit shall file by the appellant on or before ITNA, bringing on record the order that has been passed by this order. My lord, we accordingly filed, my lord. Then next, your lordship, again your lordship's order on 23/9/2025. Till the last part, my lord, of that day, till the next day, the undertaking given by the Learned Counsel for the petitioner shall remain stayed as per the order dated 7/5/2025. Thereafter, 24/10/2025, Interim order passed earlier shall continue to the next date of listing. 2410, then last order is of 1711, my lord. So, my lord, where is the question, my lord? Well, I do not know how the submission has been made, my lord, that there is no interim order operating. Either an interim order in the form of, my lord, undertaking given by them.
Just undertaking.
Yes, my lord.
They will not pursue with the
Yes, my
matter.
lord, but they are making a submission. Or that aspect may be made clear, my lord, and the warrant of why warrant should not be issued. The so cause has been given. There should be, my lord, lordship pass a specific order to that effect.
Have you filed a separate?
No, Lord, we have not. We have just come to. Stay application is there. IA is there.
Application is
I there. IA is already there, but order has not been passed in the IA, my lord. The order has been passed in the main case. 252.
This was passed on 16/12/2025. You could have brought this on record by filing one small affidavit. This was passed way back on 16/12.
Yes, my lord.
You could have filed or brought this on record by filing affidavit, additional affidavit.
You missed the
In fact, there were some intervening holidays in between, so in fact.
We missed the order, actually, Your
I
Lordship.
had shared a copy only today with them.
Today we came to know only, my lord, while in court.
Because
So what do we do? So this.
In fact, my lord, fairness demands that since your lordship is fixing it for final disposal, fairness demands that the execution proceedings be kept in abeyance till the matter is finally heard.
My issue, my lord, that was there. When the matter was taken up on 7/5, my lord, before this honorable court, the question of stay had come. My issue on the point of law on that day was that I have a money degree in my favor. So without deposit of any security, can there be a stay unconditional?
Right.
So that was the issue, my lord. At that juncture, my lord, since the matter was otherwise the records had already come, it was thought that, my lord, the hearing would take place. And therefore, as of now, I said that, okay, we will not proceed. We are, in fact, from our side, we have not taken filed any further petition or taken any further steps in the execution court till now.
But it has come by
But
itself.
then, my lord, since there's
This matter came before the trial court by itself.
my lord.
But
because trial court again, my lord, they have to give status reports these days for execution cases. So they have to fix dates and the matters get.
Because
listed,
you have undertaken that you will not pursue the matter.
My lord, my point would be that if the IA, therefore, on stay is specifically taken up on the next day.
Okay.
And the issue whether there can be unconditional stay or not, if that is taken up by them. If unconditional stay is granted, my lord, it becomes a appealable order for me. So I also get some remedy, my lord.
Well, with due respect,
I am also remedialess.
with due respect, my lord, my submission is that on that.
What is the amount involved, decree amount?
500 crore, my lord. Earlier, my lord, we have paid the entire amount, that awarded amount, initially. Now, this amount is 500 crore, basically enhanced amount, and that too, my lord, on the ground that, my lord, 2013 Act applies.
Okay.
And in my humble submission, my lord, the law is very well settled, and all that, my lord, I can swap to my lord, that it is 1894 Act, Land Acquisition Act apply, not 2013 Act will apply. We award was of, my lord, 2011. The Act came in, my lord, 2014.
That is the bone of contention, my lord.
No, I'm not saying, my lord, that on when the matter was moved up, my learned friend should not have said that, no, we will not, my lord, proceed, my lord. Matter was heard by this honorable court on 7/5. And court was about to pass the order, this honorable court. That at that point of time, my lord, my friend said that, no, we will not proceed with the execution case.
Okay.
Mr. K. Agarwal. My lord, 7.
Well, I am visiting, my lord. I remember everything, my lord.
Also remember, my
Mr. K. Agarwal, Lana Senior Advocate, assisted by Mr. D. Senapati, Lana Counsel for the appellant. Also had Mr. B. Pathak, Lana Counsel for the respondent number 1 to 71, and I. Chaudhary, and Mr. I. Chaudhary, Lana Advocate General, Arunachal Pradesh, for the respondent number 72 staff, on the consensus agreement of the parties. Let this matter be listed on 24 February for final hearing. So, Spare, Mr. Agarwal, Lana Counsel for the appellant. Term is that on
My lord is searching 7/5, my lord. 7/5.
7/5,
2025.
2025. The Lana Counsel for the respondent execution petition has undertaken that they will not pursue with the execution petition being execution case number 0320, execution petition pending before the district pending before the district court. Hello.
That is execution case number 3 of 2025.
Okay, the execution case being execution case number 03/2025 in, what is this reference case?
A reference, my lord, which, my lord, that was disposed of.
Okay.
Against that, we have filed the appeal here, my lord.
And the same has been continued from time to time till 17/11/2025. However, on 16/12/2025, the Lana District Judge took up the execution petition and on the submission of the Lana Counsel for the decree holder that there was no any interim order passed by this court in the by this court has issued has passed issue notice already.
As of now, notice only. But they have not filed any formal reply. Had this situation been explained properly before the executing court, my lord?
Hereby issued notice to the judgment letter. Okay, this is only notice only.
Notice only.
No need.
The notice
Only
has been
notice.
issued, but my lord, the notice,
You file reply explaining all this then? It's better? I thought it's yes. Not required?
Because why I think.
my lord, when the matter is, my lord, already pending, my lord, and
Yes,
the
yes.
interim order.
You annex this order and which continue till that, and then you explain. Although
Lord,
this is
we
not-
have already filed affidavit as directed by this honorable court. We have explained everything earlier, my lord. It's not that, my lord, everything.
No,
Last
before the
order,
execution-
last order was also,
Before the execution court.
last order is also, my lord, your lordship will kindly see. Further, he has been stated that as per order dated so and so, it has been mentioned that the interim order passed earlier shall continue till the next date of
No,
hearing.
that is there. You explain this before the execution court.
My lord, we have explained, my lord. It's not that, my lord, we have not explained. In spite of that, my lord, your lordship, having produced this honorable court's order, my lord, this order has been passed.
So things
So,
remain.
my lord, some protection, my lord, your lordship will say that the execution proceeding be kept in abeyance till then, my lord.
Okay.
Because this confusion, my lord, had come because this 7-5 order, the last line, the court
Okay.
says that we
The
restrain
okay,
therefore from
execution
prosecuting the interim order.
issued notice
So
to
therefore,
the
the court thought that there is
issue
no
notice to
interim
the judgment debtor. Under Order 21, Rule 37 of CPC to show cause as to why warrant of arrest should not be issued against him. Stopper. Since on consensus agreement, the matter has been fixed on 24 for final hearing, it is provided that the execution no, not so, but without condition, the execution petition again cannot state what he said.
My lord.
So this only this notice.
That notice may be stated.
Hmm.
That I agree.
Okay.
That will do.
The
That will do, my lord.
okay.
The notice will be issued, we'll file an application there again.
Okay. The notice issued to the judgment debtor by the session, by the district court on 16/12/2025 shall remain stay till the next date of listing. Okay. Okay.
No, that clarifies it.
Obliged.
For the earlier, my lord, order will continue, my lord.
Okay.
Item 20.
So that continuation is already, my lord, creating all the
Okay,
confusion.
That earlier order, undertaking of 7-5 continue, my lord. The second case, my lord, let it be along with that, my lord.
Okay.
No, my undertaking is from my side, my lord. If I don't give, my lord.
Has to be withdrawn. Yeah. That will be better.
Further, it is made clear that till the next date of listing, the earlier order dated earlier order dated 17 just
17/11.
No, 7/5.
7/5/2020.
Okay.
Would be a better reference, my lord, because that is in detail.
Hmm.
So 7-5 says there is no interim, but
The execution proceeding.
is interim.
Okay.
So therefore, some confusion.
The execution proceeding shall remain stayed as per the order until the next hearing. the execution proceedings shall remain in state as per the order dated 7/5/2025. Okay.
My lord, the second case is also is together, my lord. Let it.
Item number 20 is a bit different. We are challenging the dismissal of the reference matter by the appellate authority, reference authority.
The open है क्या? Issue involved is same, my lord. The larger issue is same, my lord, in both the cases. Whether the Act 1894 will apply or 2013 will apply. Because they filed a reference under section 64 that was held to be time barred.
Here, what interim order was passed?
Here, interim order.
The interim order is
No
not
interim
required.
order. Here, no interim order is there.
Otherwise, this can be hard, my lord, this matter can be heard and
We heard together.
Yes, my lord.
Okay, Mr. Mr. S. Maulani, counsel for the petitioner.
Amikar Karna.
Mhm.
my
Okay.
lord,
And Mr. K. Agrawal,
I am appearing for respondent 1 to 71.
counsel for the respondent number 2 are present.
Kuntu.
I request that let this matter be listed along with
Boken hai wo.
the item 20R.
Respondent number 2.
Huh? Oh, sorry. Respondent number 2, my lord.
19, huh? Yeah.
I'm sorry, my lord. I'm respondent number
Yes, yes, recorded. Along with item 19, huh? On 24/2/2025. Okay.
Abla.
Huh? Okay.
Item number 10, password matter.
So, Lordship, I have gone through the record, Your Lordship. The statement of the victim has not been recorded and the next date is fixed on 5/2, Your Lordship. Due to the paucity of the time,
Okay, her
her deposition could not
deposition could not be
be
recorded.
taken up, yes.
So what do we do?
Your Lordship, even otherwise, Your Lordship, this is a very different case from a normal POXO case, Your Lordship. In this case, both the accused and the victims are biological brother and
Okay,
sister.
okay. So in that case,
In otherwise, in every matter, Your Lordship, if deposition of the victim is to be awaited, because there is every chance since all the witnesses as
we
well
do
as
not know what would be her deposition.
absolutely, Your Lordship.
She might implicate also.
Yes, Your Lordship.
So then, since it is fixed on 2nd February,
February 5th, Your Lordship.
February, how many days left? Okay.
It's almost
Yes, almost a month.
Your Lordship. Because otherwise, if the accused is released on bail at this stage, Your Lordship will see that
Yes, she is out and in the same house.
same house,
It
even
will be
the
difficult.
Your Lordship will see the complainant, who is
Right,
the
right.
informant has clearly stated that they
The
don't have
offense,
objection.
offense happened, but then of course only because they are biological.
Yes, Your Lordship.
Brother.
This thing has to be taken seriously, Your Lordship. Otherwise, also, Your Lordship, in the judgment of XXX versus State of AP, the court was clear with regard to first taking up the deposition before the court
Now, because
and to consider
the victim here in this case, it appears that doesn't have any complaint.
Yes, Your Lordship. However, she is a minor, Your Lordship.
Only because he is because that is immaterial only because she is minor.
Yes. Otherwise,
And then-
also, if we take it social as in terms of the social things, Your Lordship,
The trouble.
this is not a good case, Your Lordship.
Or what do you want?
Lordship,
Let the victim be let the deposition of victim be
the dates are being fixed after 4 months, 3 months, 4 months only.
Now, since it is already
Here, Your
fixed
Lordship,
on
the police-
February, because otherwise the case is clear and it deserves rejection.
Lordship, here the
Difficult. How do we justify? How do we justify for granting bail in such case?
Yes, Lordship, I'm coming. Here in this case, Your Lordship, the plea which I have taken is not on merit.
Okay.
I am relying on the judgment of Supreme Court, Your Lordship. There are a few judgments, Pravir Purkasto and then Vihan Kumar, and also Mihir Rajesh also, Your Lordship.
Yes. Says also Kashi
So
Reddy.
that, apart from that, your lordship.
You have a latest judgment. you
It's
said.
Mihir Rajesh Shah, your lordship.
Okay, what
Mihir
what it says?
Rajesh Shah is more particular about when a
Lordship's
ground
judgment
of
is also.
arrest has to
Yeah,
be
that is-
produced.
oh.
It's if a person is arrested, your lordship, prior to he being remanded, your lordship, and produced before the concerned magistrate, your lordship, 2 hours prior he has to be given a ground of arrest, your lordship, ground of reason for ground of arrest, your lordship. But in this case, your lordship, like I have already submitted, your lordship, because if your lordship will see why my submission is more particularly based on this is like, if your lordship will see there is a difference of when the accused is being arrested, if he is not given a ground of arrest and then he is produced before the magistrate, that plea can always be taken, your lordship, when he is under the remand, under the police custody, your lordship. Once the charge sheet is being filed, your lordship, if any bail is being filed before the concerned magistrate, even during the pendency of the investigation or even during the pendency of the trial, that's where the court has stated that he has come to know about the ground why he was arrested, because he have full knowledge about the charge sheet. He is participating.
Do you have an
in trial.
authority?
Yes.
Any authority?
Therefore,
Kindly
your
stop.
lordship.
Otherwise,
Therefore, your lordship, if your lordship kindly give me a time till Monday, your lordship, because tomorrow and day after tomorrow,
Your lordship.
tomorrow and day after tomorrow, your lordship, I'm not coming to the court due to some personal difficulties, your lordship. On Monday, your lordship, because even on earlier occasion, I have made the similar argument, your lordship, in terms of, because your lordship will see whatever case is under trial, this will open a Pandora box, and therefore, it was very specifically stated the stages of the ground of arrest, your lordship. If your lordship only fix this matter on Monday,
Statute
only
violation, your lordship.
Mr.
Lordship, kindly,
Mr. A.K. Singh, learned counsel for the petitioner is present. Ms. T. Ginny, learned additional PP, prays for some time to place his point of argument. Please pray for Kama, list this matter on when do you?
Lordship,
Your lordship.
tomorrow, your lordship, tomorrow.
not
It's a bail
tomorrow.
matter, your.
If tomorrow is, I'm not, your lordship, I have taken a.
Tomorrow, is there a court tomorrow?
But
Tomorrow is
day
holiday.
after,
Day after tomorrow, I'm not available.
Okay,
your lordship.
when-
7, 8, and 9, I have to go to the PTC since
Okay.
there is
Okay,
a,
next day.
there is
Then
on 19.
7, 8,
otherwise.
and then in 19. Okay.
Yes.
This matter on 19. Okay. So on that day, supposing if you fail, then probably we have to consider his bail.
Yes, your lordship.
Lordship,
If they are not arguing on the merit and only on the point of ground of arrest, I'll try to convince this court.
No,
with
not
regard
on
to-
merit, on ground of arrest.
Yes,
On
they
merit,
are not
with the
in
legal
ground
part,
of,
since he's now a point.
is only
that,
ground of
this
arrest.
bail application is on only on ground of
Ground of arrest, your lordship.
arrest.
in
Not
Vihan,
in comment-
in
not in
Vihan
comment
Kumar's
period.
case, your lordship,
Yes, yes.
even if the charge sheet is filed,
You're entitled
then
to that.
also.
Yes.
Hmm?
Okay,
Maybe fix on 20.
okay, 20.
No, 20. नहीं होगा 21 21 को मेरा आलो
You said 19, but it's-
इसलिए तो 20 को हम आलो जाना ना 19
0 में
होगा तुम किसी को रख लेना otherwise you're not arguing on that matter ना 19 your lordship
19.
Next Monday, next Monday also, if you are here. Then.
next Monday is छुट्टी है ना
You have no objection, it appears. And on the ground of non-communication of the ground of arrest, probably you will have no say.
yes your lordship
Okay, no problem. Okay,
deeply obliged.
but then you have to be present. Huh?
Yes.
Okay.
Item number 12.
My lord, in item number 12, I'm appearing for the respondent. I wish, my lord, I could have appeared physically before your lordship, but my medical condition is
Your
such.
correspondent number,
My
respondent.
lord, the sole respondent in the election petition, because we don't
Yes,
have
yes.
other private parties. So, my lord, what I was saying that, my lord, I wish I could have appeared physically before my lord, but my medical condition is such that I do not have any other alternative
No,
But
no
to
problem.
appeal
No problem. Your associate, juniors are there.
Very well. Now, my lord, in this election petition, there is interlocutory application filed by the respondent, that is IA 315 of 2025. IA 315
Yeah, this is for what?
of 2025. You know, this IA is under Order 6, Rule 16 of the CPC for striking of pleadings in the election petition. Now, my lord, for a moment, lordship may kindly turn to my lord, Order 6, Rule 16 of the CPC.
Just a minute. Huh?
Very well.
रिप्लाई है क्या उनका ऑब्जेक्शन ठीक है नहीं ये मैं डाटा तो शायद ऑब्जेक्शन वाला दिया था ये नहीं है साथ में था नहीं जरा से तो हाँ दो लाख के चला दिया
Oh, this is fixed for today.
Yes,
I thought
my
this
lord,
is for exhibitions.
No, it is
Marking of
fixed
the
for today,
exhibition.
striking of pleadings. Now, my
Okay.
lord, since the interlocutory application has been filed under Order 6, Rule 16, for a moment, my lord may turn to Order 6, Rule 16 of the CPC. I read, my lord.
Just a
The
minute.
court-
Order 6, Rule 16.
16,
Striking
yes.
Proceeding.
I read, the court may, at
Just
any
a minute,
stage
850.
of the proceedings,
Mhm.
these words are important. The court may at any stage of the proceedings. So, my lord, it can be at any stage of the proceeding. Order to be struck out or amended any matter in any pleading, A, which may be unnecessary, is scandalous, frivolous, or vexatious. Now, my lord, the ground on which we are seeking striking of pleadings, my lord, here I reiterate, what we are seeking is striking of the pleadings, not amendment of the pleading. Because pleadings in the election petition cannot be amended at the behest of the respondent. The law on that is settled. There is no difficulty. What we are seeking is striking of the pleadings. Striking of the pleadings on the ground of A. The ground is specified in A, that is unnecessary, scandalous, frivolous, or vexatious. Out of this, my lord, I will be pressing only unnecessary and frivolous. My submission is going to be that the pleadings striking off of which we are seeking by way of this application are in the circumstances either unnecessary or they are frivolous. Therefore, they have to be struck off. Now, my lord, here certain facts are very important. To begin with, let me draw your lordship's attention to the order dated 28th October 2025. On 28th October 2025, total 11 issues were framed by this honorable court. 11 issues were framed. This order, my lord, will find at page 9 of the interlocutory application. The relevant portion, my lord, is page 11. At page 11. 11 and 12. My lord will see total 11 issues are there. Now, out of these 11 issues, total 11 issues were framed on 28/10/2025. Now, subsequently, my lord, election petitioner filed an interlocutory application, that is IA 292 of 2025, that was filed under Order 14, Rule 5, for deleting issue
IA?
number IA 292 of 2025. This IA was filed under Order 14, Rule 5. My lord, Mr. Deori, the learned counsel assisting me, is having the copy of the IA. He can give it to your lordship. Now
Where
here,
is the
my lord,
courts? This IA.
this IA was filed, my lord, under Order 14, Rule 5. That is for deleting issue number 7 and 9 out of the 11 issues framed. Now, in this very IA, the IA was filed on 26th November 2025. In IA, my lord, two paragraphs are very important. The reason for which election petitioner filed this IA. Paragraph 4 and paragraph 5 of the IA may kindly be seen. Paragraph 4, my lord, I read. At page 3 of the IA, it is stated that the nominations filed by the candidates along with the affidavits under Form 26 are displayed in the notice board of the returning officer.
No, just para, you said para?
My lord, this is, I'm sorry. There is a mistake by me. There is a mistake. I did, there is a mistake. Where is the copy? Para 4 and para 5, my lord, I'm reading paragraph 4.
4 of IA.
Yes, my lord, para 4 of IA.
Just a minute. Sir.
IA 292. The
IA
IA
292.
which Mr. Deori has given to your lordship. The IA filed by the election petitioner under Order 14, Rule 5.
Yes, page 6.
Page 6, internal.
292.
Relevant paragraph is paragraph 4.
Okay.
I read paragraph 4 that the applicant respectfully submits that the core and substantial grounds urged in the present election petition relate to material defects in the respondent's filing of nomination paper, including false declarations under Form 26, which directly attract Section 101(d)(1) and other relevant provisions of the Representation of the People Act 1951. The petitioner does not wish to pursue or press the allegations concerning booth capturing, rigging, or other related corrupt practices forming the subject matter of issue number 7 and 9, as the petitioner intends to confine the adjudication of the election petition strictly to the principal grounds relating to improper acceptance of nomination, not opening a separate bank account for monitoring election expenditure, and filing of defective and false affidavit For easy reference, issue number 7 and 9 are reproduced here under. So, my lord, the issue number 7 and 9, deletion of which election petitioner prayed for, my lord, they are quoted over here, and I read issue number 7, whether the respondent elected candidate is guilty of corrupt practices as defined under section 123(2) of the Representation of People Act 1951, more particularly relating to the alleged booth capturing malpractices and rigging at the polling stations as pleaded in the petition. Issue number 7, that is. Now issue number 9, whether the allegation of booth capturing, malpractice, rigging, etc. lack material particulars as required under section 135 capital A of the Representation of the People Act 1951 for making out a cause of action of commission of corrupt practice under section 101B of the Representation of the People Act 1951. So, my lord, these were the two issues, number 7 and 9, out of the 11 issues, deletion of which election petitioner prayed for in his interlocutory application, and categorically, my lord, averment of that nature was made in paragraph 4. These two issues, my lord, as lordship has already noticed, were related to booth capturing, rigging, and corrupt practices relating to the booth capturing and the rigging, etc. Now, my lord, paragraph 5 is equally important. This may also kindly be seen that the applicant submits that continuation of issue number 7 and 9 is no longer necessary for complete and effective adjudication of the real controversy between the parties. And their consideration would only lead to unnecessary enlargement of the scope of the trial, causing avoidable delay. Therefore, it is humbly submitted that under the Order 14 Rule 5 CPC, read with Section 151 CPC, be pleased to strike out or modify issues before the examination of witnesses starts in order to ensure that only such issues as are necessary for determining the matter in controversy remain for trial. So, my lord, these were the averments, and on the basis of the prayer made in IA 292, my lord thereafter passed an order. Order, my lord, on 3/12/25 order was passed. The 3/12/25 order, my lord, will find at page 14 of the present IA, that is 315. Page 14. It is your lordship's order. The relevant portion is page 15. So, my lord, accordingly, 7 and 9 were deleted and total 9 issues were framed by this order. 9 issues were framed. Issue number 7 and 9 were deleted, and accordingly, my lord, other issues were renumbered. Now, my lord, since issue number 7 and 9 were directly related to booth capturing, rigging, and corrupt practices relating to both, therefore, my lord, we filed the present IA, that is IA 315 of 2025, for striking of the pleadings which are primarily connected with the allegations of booth capturing, rigging, and corrupt practices relating to both. This is the purpose of the present IA. As my lord, I have submitted earlier, under Order 6, Rule 16, at any stage of the proceeding, application may be filed for striking of pleadings on 3 different grounds, one of which being to strike off those pleadings which may be unnecessary, scandalous, frivolous, or vexatious. Our case is that in view of the deletion of issue number 7 and 9 on the prayer of the election petitioner, the pleadings which are directly connected with booth capturing, rigging, and corrupt practices connected to both have become wholly unnecessary and frivolous. Since those pleadings have become unnecessary and frivolous, the ground under Order 6, Rule 16A is directly attracted. So, therefore, my lord, these pleadings should be struck off from the election petition. That is the prayer. Now, my lord, the relevant paragraphs in the election petition, which are directly connected with the allegations of booth capturing and rigging, are as follows. My lord, though in the prayer, applicant has mentioned paragraph from paragraph 17 to 30, I will not, my lord, make my prayer in respect of all these paragraphs. Some of the paragraphs may be omitted from our prayer. The paragraphs, according to me, which are directly related to the allegation of booth capturing, rigging, and corrupt practices connected with both, are paragraph 18. My lord, I'm repeating those paragraphs. They are not 17 to 30 straight away. These are paragraphs 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27. Now, my lord, I will deal with these paragraphs in seriatim. I will refer to each of the paragraphs and I will show as to why, my lord, these paragraphs have to be deleted, struck off from the election petition. Now, Lordship may turn to straight away paragraph 18 of the election petition first. There are other paragraphs also, I will come to them later. Paragraph 18. At page 51.
Page?
Page 51 of the election petition, paragraph 18.
The election petition, I think.
Yes.
51. It is
Page
start from 20.
51 of the election petition, paragraph 18.
51.
51, yes.
No. It's not 51.
My
If
lord,
it is a
in,
paragraph 18,
It's page 51.
51, no, it's para 20.
Maybe, my lord, there is
Page
some
51
problem.
is para 20.
Then there is a pagination is not matching. The copy which was given to me, my lord.
Pagination is
Anyway, my lord, I'm
43.
referring to paragraphs
paragraph 18 is at page 43.
because with pen also another page number is given over here. Anyway, my lord, let it be. I'll confine to paragraph numbers. Paragraph
Okay.
18. Paragraph 18. I read this paragraph, my lord.
Yes.
That the petitioner begs to state that the election of the returned candidate has been materially affected by incidents of booth capturing and booth rigging that occurred on 19/4/24, the date of polling for the 11th Arunachal Pradesh Assembly constituency election. Regard also need to be given to the fact that on 16/4/24, the petitioner's election agent, Sri Raj Pao, wrote a letter to returning officer, Nayan Chand Tajo, ST Assembly constituency, East Kamen district, wherein he flagged concerns of possible booth capturing of certain polling station, namely such and such, such and such, such and such. So Lordship finds the paragraph 18 talks about only booth capturing and booth rigging, and my lord places certain facts in connection with that. There is nothing else in this paragraph. Then, my lord, comes paragraph 19. The petitioner begs to submit the chronology of the events of malpractices in the 4 polling stations which have been laid down for the perusal of the Honorable Court. So, my lord, in para 19, the chronology of the events of malpractices regarding booth capturing and rigging in 4 polling stations. The first polling
Events of
station is
malpractice in the 4 polling.
19.1, that is Nari Camp polling station 17. The details are there pertaining to that. Then para 19.2, Kapu Dada polling station 32. Then, my lord, 19.3, View polling station 2. All the details. I'm skipping it off, my lord, because there is nothing else in these pleadings. Then 19.4, Krema Pao polling station 19 at page 49. All the details. Then, my lord, the next is paragraph 20.
Paragraph?
Paragraph 20, 20. 18, 19, now I come to 20.
Yeah.
Para 20, Lordship finds, I read, that the petitioner begs to state that on 22/4/24, the returning officer of 9 Chiang Tajo Ski Assembly Constituency, East Kabeng District, replied to all 4 representations concerning incidents at Nari Camp Polling Station 17, Kapudada Polling Station 32, Vio Polling Station 2, and Prema Pao Polling Station 19. The returning officer refrained from entertaining these representations on the formal ground that the petitioner's election agent did not make any formal submission. Notably, similar representations for all 4 incidents in different polling stations were dismissed on identical grounds. All the representations were rejected on a uniform and arbitrary ground, stating that the petitioner's election agent, Sri Raj Pao, did not make any formal submission regarding incidents of malpractices, booth capturing, and booth rigging. The petitioner vehemently denies this reply as if it is a matter of fact, such and such, such and such. So that is nothing else, my lord, again, booth rigging and booth capturing. Then paragraph 21. Para 21, that it is respectfully submitted that the Honorable Supreme Court in Basangoda such and such highlights the concerns surrounding booth capturing and further reiterates such practices of booth capturing and rigging are corrupt practices. So, my lord, the law on this has been discussed on booth capturing and rigging as to how it amounts to corrupt practice, and the Supreme Court judgment has been quoted. Then, my lord, paragraph 22. That the petitioner begs to submit that section 135A of the Representation of the People Act 1951, which renders booth capturing as an offence, provide for various forms of malpractices in which booth capturing, so my lord, legal submissions in connection with the booth capturing, malpractices, connection with the booth capturing, etc., etc., and my lord, the principles of law connected therewith. There is nothing else in paragraph 22. In extenso, they have quoted. They have also quoted section 135 capital A. These are all legal submissions. Then, my lord, comes paragraph 23. Para 23, that the petitioner begs to state that not only does the element of corrupt practice make the respondent liable to be disqualified, but also the fear induced by such malpractices extends far beyond the isolated incidents themselves. It permits the entire environment surrounding the exercise of adult franchise, impacting the integrity of the electoral process. The calculation of these malpractices cannot be confined to mere incident, but must consider the broader context of how many votes may have cast their ballots under duress, compelling to avoid coercion, such and such. Individuals wielding muscle power. So, my lord, again, that rigging and malpractices and booth capturing, etc. Connected, that it is connected with that only. Then comes paragraph 24, that the petitioner begs to state that during the counting of postal ballots, the due process was not followed as mandated by the Representation of the People Act. So, my lord, when you talk about the counting of the postal ballots, you again enter into the arena of, my lord, booth capturing and malpractices related thereto, etc., etc., and the rigging. Because all these grounds have been completely given up by the election petitioner. Then, my lord, various parts of para 24, para 24(1), petitioner and their election agent were deliberately given a very short notice regarding counting of postal ballots, depriving them of their right to partake in this critical phase of electoral process. This omission directly contravenes Rule 56(d)(3) of the Conduct of Election Rules, etc., etc. All postal ballot they are dealing with. Then para 25, that the petitioner begs to state that another aspect which warrants serious consideration is the non-deletion of name of expired voters by the booth level officer, Sri Rahul Mangam, and the resultant casting of proxy votes by deceased voters, those who passed away before the date of the polls on 19/4/24, whose names were not struck off their respective final electoral rolls. So, my lord, again, the casting of the votes of the expired voters on non-deletion of the names of the expired voters, etc. These are the malpractices connected with, my lord, booth rigging, booth capturing, counting of ballots, etc., etc. Because, my lord, according to election petitioner, the main focus now is only on the omissions of the returned candidate in Form 26 affidavit. The omissions made by him in the Form 26 affidavit, that is the basic thrust of the election petitioner. Then, my lord, paragraph 25.1 is again regarding the 9 Chang Tajo Assembly constituency, non-deletion of the names of expired voters, etc. No issue has been framed in connection therewith. Then 25.2, the petitioner produced herewith the list of deceased voters whose votes were found to have been cast on the day of polling. So casting of the votes by the deceased, according to him, those voters were dead. No issues framed because focus is on Form 26 affidavit. These are the malpractices which are directly connected with the counting of ballots. Then the details, list, etc. Then comes about paragraph 26. The petitioner has wide letter dated 19/6/24 has requested the Deputy Commissioner cum District Election Officer, East Kamen District, Sepa, Arunachal Pradesh, and Returning Officer 9 Chang Tajo ST Assembly constituency for providing use Form 17A of Kapudada, Krem Pao, such and such, such and such. That is it. Form 17A, my lord, because when you go to cast your vote, the Form 17A is there, where details of the voters are given. It is for that purpose. So then comes, my lord, the paragraph 27, that the petitioner begs to state that the actions of election agent and supporters, paragraph 27. Para 27, that the petitioner begs to state that the actions of the election agent and supporters of respondent in the 4 polling station, namely Nari Camp polling station 17, Kapudada polling station 32, Vio polling station 2, and Krema Pao polling station 19, constituted corrupt practice of booth capturing, booth rigging, and other prohibited activities under Section 123, subsection 8 of the Representation of the People Act 1951. These actions render the candidate's election void under Section 101B of the Representation of the People Act 1951. The corrupt practices committed by the supporters of respondent, including casting votes of deceased persons whose names were not struck off the electoral roll, fall under the purview of Section 101D2 and have materially affected the result of election in favor of respondent. So that is it. These are the paragraphs, my lord, directly connected with the malpractices which constitute, my lord, which are in relation to booth capturing, poll rigging, counting of ballots, etc., etc. Because now the entire focus has gone on Form 26 affidavit and the omission.
.1 and
6.2.2 and paragraph 8. Though, my lord, I must clarify here that so far as election petition is concerned, election petitioner, my lord, is very clear that he is focusing on Form 26 affidavit, the omissions committed by the written candidate in filling up the Form 26, that is his primary focus. And I must, my lord, also admit that these 3 paragraphs, para 6.2.1, 6.2.2, and paragraph 8 are directly related to Form 26 affidavit. So to that extent, election petitioner can very well argue that why these paragraphs be struck off. He can very well say that, and I will explain the reason why. The reason is, my lord, these 3
we'll continue at 2.
Oh, very well, my lord, at 2 will.
Okay.
I'm sorry, my lord, I didn't keep track of the time.
You got something to mention? Yes.
My lord, if my idle state can be taken up, it will take just 5 minutes.
Okay.
Yeah.
Item number 21, unlisted matter.
It's okay.
My lord, The fact of the case is that, my lord, in 2020, my lord, the deceased was brought by, before my lord, I help my lord, brought by her elder sister to the alleged accused person in this case.
Deceased?
This is a 20 years old girl, my lord, who has committed suicide, my lord.
Okay.
Then, my lord, two things are there, my lord. One, we have.
Let us see the
No, no,
FIR.
no, my lord, just I am explaining.
Hmm.
My lord, there is no copy of the FIR, my lord. One. Two, my lord. The, two is that, my lord, just after filing of this case only, when I spoke to when the officer in charge, through some sources, has shared the case number and the sections, my lord. This
The case is of 2020
25.
or 25.
25. Recently,
Okay.
on 29, my lord, it is like this. In 2020, the elder sister of the deceased brought her to Yazali, and the accused, and they are known to each other for long, with a request that if she can get her admission in BKV Yazali. And accordingly, my lord, she was the alleged accused person who is apprehending arrest, has facilitated, my lord, getting her admission, my lord. And that, my lord, will kindly see those admission part. My lord will kindly see from here. In order to page 18, my lord, kindly come, then I'll narrate the whole thing, my lord. Just to fact, I'm narrating the fact. 18, my lord. Page 18. She was brought there. She was admitted in this school, particular school, my lord. And then again thereafter, my lord, page 19, my lord will see. She was, she got admission in the Vivekananda Kendra Vidyalaya, Yazali, NEPCO colony, my lord. And from class 5 to, my lord, class 10, she stayed with the alleged accused person, my lord. My lord, kindly come to, these are document, page 28, my lord, kindly come. My lord, then what had happened? Then first photograph, my lord, Poman Pansa, my lord. The regional office, Guwahati, final list of candidate registered, my lord. So from class 5 onwards, she has been staying with the alleged accused person, my lord. Then thereafter, she has been facilitating her education. But my lord, on 29, my lord, what had happened was, her elder sister, Jyoti Pansa, booked a ticket for her online for the Tata Sumo to go to the native village, to Naharlagan. And on the same day, next day morning, she hanged and committed suicide. But that story, my lord, will find. My lord will kindly come to page 30, my lord. This is a News 5 report. Page 30, my lord.
Yes.
The incident came to know from here, my lord. 17-year-old girl from Wakka in Laundering district was found hanging at her cousin's residence, my lord will mark. Cousin's residence on the road to Julang here early Monday morning, officials said. According to information received, the minor had reportedly fled from her employer's house, my lord, in Yazali and reached her cousin's a day earlier. My lord, I'm pausing for a moment here. My lord has seen from page 19 onwards to page 28. She was never been my maid. In fact, on humanitarian ground, on the request of her elder sister, I was facilitating her education, my lord, and getting her admission in the BKV and giving the best education, my lord. and tuition also was there. But in the even such kind of report, one-sided media trial, my lord, Lakpa Pangsa, General Secretary of the Vancho Welfare Society, my lord, Itanagar said a vehicle had been arranged to take her back home. However, when the driver tried to contact her around 5:30 a.m., her call went unanswered. A friend who was sleeping in the same room later woke up and searched for her, only to find the girl hanging in another room. He said police reached the spot, but no FIR was filed by the family at that time. The body was later taken by her family in an ambulance to Waka early in the morning. Miller. Next page. Miller. Taking cognizance of the matter. Now, my lord will mark this. This is important. Miller. Taking cognizance of the matter, the Child Welfare Committee CWC Londing on Monday filed a suo motu case at Londing Police Station against the employer, an unknown trafficker and mother of the deceased. The case has since been forwarded to Waka Police Station. My lord has seen the cause of action. The suicide has been committed here in Itanagar, and the Child Welfare Committee takes suo motu cognizance of the case and lodges FIR initially at Londing Police Station. Then, since the deceased hails from the Waka, it was transferred to the Waka Police Station. My lord. So FIR was lodged. So, my lord, this is the fact, my lord. Then, my lord, what had happened is, on the same day, my lord, after FIR was registered, my lord, after the FIR was registered, my lord, one thing was that on 31/12/2025, my lord, 31, I have narrated in paragraph 9, page 8, my lord.
Page?
Para 9, page 8, my lord. Waka police visited my house since I was away for the New Year celebrations and all. On 31/12/2025, my lord.
Page 8.
Page, para 9, page 8, my lord.
Okay.
And the description is.
FIR of the laws on 29/12.
29/12, my lord. And it was registered on 30, my lord. Just after filing this, my lord, I have received the details from them, my lord. Sections, all the sections, everything I have received, and then I'll provide after a while. Now, on 3/1/2026, the Londing police has repeatedly reached Yazili in connection with the investigation, as informed to the applicant by her family members. In view of the above, alleged accused is living under the apprehension of the arrest, despite having acted solely in humanitarian ground, my lord. Now, my lord, why? My lord, what had happened? The police came twice, my lord. The family members of the alleged accused person, my lord, who is apprehending arrest, has asked them to disclose the case number and sections. They have not given it. My lord, in para 10, I have written the judgment, my lord. Para 10, next page, my lord. That is Youth Bar Association of India versus Union of India, 2069 SSC 473, my lord. That the applicant most respectfully begs to submit that when the Waka and Lunding police visited the residence of the applicant for the purpose of arrest, the family members of the applicant requested the police official to furnish a copy of the FIR/complaint. However, the police official failed and neglected to provide any such copy of the FIR or the complaint to the family members at that time. Such action is in clear violation of the mandatory directions issued by the Honorable Supreme Court in Youth Bar Association of India versus Union of India, 2009, 969 SSC page 473, wherein the Honorable Apex Court categorically held that a copy of the FIR must be supplied to the accused or made available without delay. So since, my lord, in spite of making requests, they could not provide. So therefore, my lord, the case number is 03/2025. Sections are there, my lord. Now, my lord, in this backdrop, my lord will only, I request my lord only to ponder, my lord, the territorial jurisdiction, my lord. Now, earlier in the old CRPC, my lord, section 177, the jurisdictional police station, my lord. So the suicide has been committed at Julang. She left Yazali, and now in the BNSS, my lord, it is 197. So the concept of the zero FIR should have come into force, my lord. On receipt of the FIR, my lord, filed by the CWC on a suo motu basis, in that event, my lord, the Waka police station ought to have forwarded it to the Italnagar police station, Chimpu police station. Now it comes under Julang, my lord, Chimpu police station. And then instead of that, my lord, without complying with this, so therefore, my lord, the copy of the FIR and the case number could not be, the sections were not annexed. For that, my lord, paragraph 17, I have made a categorical statement, my lord. Gurbakh Singh Saiba case, my lord, para 17, my lord, if my lord can come for a moment. Page 11. There, I have written, my lord, that due to the urgency and paucity of time, the applicant has been unable to annex the copies of the FIR and complaint along with the instant bail petition. The Honorable Apex Court in the case of Gurbakh Singh Sibia versus Punjab, 1982 SSC 565 in paragraph 42 has held that the filing of an FIR is not a condition precedent to exercising the power of anticipatory bail. However, the applicant undertakes to provide certified copies of the same at the earliest opportunity to this honorable court as and when required for, my lord. Now today, my lord, since genuinely, my lord, now finally,
Oh, okay, so what we'll do is we'll take up this matter day after tomorrow. You obtain instruction and then obtain this one scanned copy of the FIR.
No, sir.
Okay,
No, sir.
we'll take up
Madam-
this matter.
Madam,
Let
till-
this matter be listed on day after
my
tomorrow.
lord, till then, kindly protect. Till then,
We'll
till,
protect.
Ah,
We'll
till-
protect. We'll pass order on that day only.
my lord, till then,
we know-
because
because it's
they are already raiding my house. My lord has seen.
now you said that they have already visited, and the police have also.
No, they have visited to arrest. I was not there. So I was in the interior village, my lord. That is my workplace where I stays in Yazali, my lord. That is where my lord, the section my lord, the reasons, the sections, my lord, I just read that I have collected, my lord. If my lord can read from here also, if my lord permits.
What is the section? Just read the section.
Section is, my lord, 143 to
What is 143?
143 kya na? 143 is trafficking of a person. my
Okay,
lord.
trafficking of
So
the-
this section will not attract in my case.
Okay.
Because I was
No, I
giving
did-
education, my lord. And my lord has seen that even for the class 10 examination
is
also I was facilitating, my lord.
Mm.
143 is punishment 7 years, my lord.
Okay.
And which is extended up to 10 years non-bailable. my lord.
Okay.
Now the section 108, abatement of suicide. Now, my lord, kindly see,
No,
has left the house, left my house,
Mhm.
and she has
So
committed
that is
suicide.
that is why we
No,
would
she
like
ha-
to see the
no, my lord.
FIR.
My lord, she has committed suicide at Julang, my lord.
Yes, yes.
So therefore,
That
10
is
years, my
something.
lord. Now there is another section, Juvenile Justice Act, my lord.
Mhm.
JJB Act section 75,
Mhm.
punishment for cruelty to child extended to 3 years, 2 lakhs fine, my lord.
Mhm.
This juvenile, my lord, will kindly see the affidavit, my lord, this page 29, my lord. Page 29, my lord, this thing, my lord. Aadhaar card, my lord.
Mhm.
And even the school admission also is very clear. 0209-2005. See. So this is 2005, my lord. So she was more than 20 years at that time.
2008.
Five.
Hmm?
5.
Where do we find 5?
2008.
2008 in school certificate.
2008 in
Even
school
the
certificate.
School certificate also 2008.
Aadhaar card.
Aadhaar card.
Aadhaar card is 2005.
Aadhaar card is 2005 and the school certificate is 2008, my lord. That I cannot conceal it.
Okay. So what we'll do is
So, my lord, my only thing, my only prayer is, my lord, kindly see the cause of
see,
action has
now you are
occurred here.
raising the jurisdiction question also. So just would like to see the FIR once.
My lord, my only request is, because that's why, my lord, there is an urgency in this case.
Now we do
They
not-
have already read it. My lord, they,
It's
lord.
only your allegation.
No, no.
It's only your.
Correct, correct. My lord, correct. I will not
We do
say
not know
anything.
where.
No, my lord is extremely correct. My lord, kindly see,
Hmm.
it is not a case of trafficking, my lord. It is not a case of abatement of suicide, my lord. Suicide she has committed here, my lord. So therefore, my lord, trafficking also does not come. From class 5 to class 10, my lord. She is staying at my home on the request of her elder sister, my lord.
That is why we do not know.
That's why, my lord, kindly till then protect me, my lord. Kindly. Even if my lord is speaking,
Day after tomorrow morning we'll take up.
my lord,
in the morning.
they are coming up, my
Till
lord.
then, just this court would like to see the FIR.
No, my lord, I am grateful, my lord. Kindly, till then, no coercive action. Till tomorrow. Till. No coercive action till 7, my lord.
Nothing will happen, it appears, because you are not there.
No, because like I have to.
No, it's very difficult unless we see.
Okay. Well, fine, my lord. What
Get it
should I?
listed day after tomorrow.
Day after, but in the meantime, the learned additional PP.
You obtain instruction on that day, otherwise you will have to pass.
Yes.
Okay.
I'm extremely grateful, my lord.
Okay. Please.
Right, Lordship.
Yes, my lord. Before the recess, I was on
My
para.
lord, I have one submission.
Hmm?
My lord, item number 8, Lordship. In item number 8, fixed date is required. Ma'am. Fixed date may be.
Item 8?
Item number 8. Fixed date may be given. It is adjourned for 2 weeks. It was.
Huh?
This is a bail item.
When do you want? You said
19.
Okay.
On 19.
Okay. Item number 8, 19. Okay. Here also then.
Much obliged.
List is matter again. On Monday. In the meantime, the learned addition PP shall obtain necessary instruction and produce the scanned copy of the FIR.
Yes, sir.
Okay. Okay.
Right.
Yes.
So, my lord, before the recess, I was.
One
two
matter is there,
paragraphs.
Lordship, unlisted. Unlisted matters. Item number 22.
Oh.
Unlisted matter.
Want to withdraw?
Yes, withdraw.
Okay. Mr.
I may be withdraw to file fresh.
Okay. Mr. Sunil S. Mo, learned counsel for the petitioner.
Only IA. Not
IA?
only IA.
What is this IA about?
IA is for the bail. So there were some technical issues.
Okay.
So
That he had an instruction to withdraw this IA. IA is for bail. IA number?
IA 122 of 2025.
122 AP. Okay. Okay. Want to withdraw this IA.
Yes.
Withdraw this IA.
To file fresh.
Criminal 122 AP with liberty to file afresh after making necessary correction. The prayer is allowed. This IA stands dismissed as withdrawn with liberty as prayed for. Okay.
I hope now I can make my submission and there is no other matter left.
Yes.
My lord, before the recess, I was on 2 paragraphs, namely para 6.2.1 and para 6.2.2. These 2 paragraphs, my lord, they refer to one particular property of the returned candidate at Jolung village, and the allegation in the election petition was that this very particular property was not disclosed by the returned candidate in his Form 26 affidavit. So, my lord, I am on that.
26.
Lordship may kindly see, my lord, para 6.2.1 at page 27 of the election petition.
Yes.
I read, my lord, that the petitioner begs to state that the respondent has not disclosed a plot of land stroke area belonging to possibly him is left out, belonging to him in the Form 26 while filling his nomination paper. the land area measuring 150,000 square feet at Julang village, which was allotted to him by land holding certificate number such and such, has not been disclosed by the respondent in the Form 26 filed along with the nomination paper. Then para 6.2.2, that the petitioner begs to state that the reason for non-disclosure is intentional, deliberate, and mala fide, and to undue influence the voter. Such non-disclosure is not only in violation of guidelines issued by the Election Commission of India as regard to the filing of nomination papers, but such non-disclosure be tantamount to undue influence upon the voters, and the same is liable to be declared as corrupt practice. Now, my lord, these are the two pleadings made in the election petition. Now, Lordship may kindly turn to the Form 26 affidavit filed by the returned candidate. The entire, my lord, affidavit, Form 26 affidavit has been annexed with the election petition, and the relevant page, my lord, would be at page 110. I hope this page is correct. In my election petition, it is page 110. Mr. Deori will kindly help your lordship because it seems there may be some mistake in the pagination. It is page 110 of my election petition. In page
Is
110.
a part of Form 26. Is this a part of Form 26?
Yes, part of Form 26.
Okay, land located at Julang.
Yes, yes. Here, my lord will find this page begins from, my lord. It deals with the details of immovable asset at page 109 of the election petition. Details of immovable assets, headlines.
Yes.
Yes. So now the next page, 110. 110, my lord will find the first column itself, the second column, the last, Roman 4. Land located at Joliang Papumpare. That is Jolung village. And this area of this land is, my lord, that is alphabetical D. Column, the next column 2. Alphabetical small d. It is 2,21,52,800 square feet. It is much more than 1,50,000. It is much more than 1 lakh. It is 2,21,52,800 square feet at Jolung village. So, my lord, this property has been disclosed by the returned candidate in Form 26. It seems there is some confusion so far as the election petition is concerned. So, my lord, in connection with these two paragraphs, my submission would be that this would fall into the category of quote-unquote frivolous within the meaning of Order 6, Rule 16, small a. Frivolous. Because frivolous is not having any serious purpose or value. A paragraph which has no serious purpose or value. They allege my non-disclosure of a particular property which has been disclosed in Form 26. Prima facie, my lord, the entry can be seen in the election petition. So possibly there was non-application of mine. So therefore, the pleading of this nature is either unnecessary or it is frivolous. Now, my lord, para 8 may remain, it cannot be struck off. So by submission on paragraph 8, I will withdraw. Para 8 will remain. I have checked paragraph 8. It need not be struck off. So, my lord, these two paragraphs, 6.2.1 and 6.2.2 pertaining to non-disclosure of property, landed property at Jolung village. In fact, our case is, it is not 1,50,000 square meter. It is much more than that. It is 2,21,52,800 square feet. Or maybe, my lord, since they have given the figure of meter, here it is a square foot. So possibly a square foot would be much more than the meter. So there is a disclosure. Now, my lord, I will turn to, so these are the two primary submissions, my lord. Under Order 6, Rule 16A, unnecessary and frivolous. These pleadings, and therefore they are liable to be struck off. Now, my lord, in their objection, the election petitioner, my lord, primarily advanced two arguments. There are two principal arguments, my lord, which they have taken in their objection. The first argument, my lord, deals with they have placed a reliance on Order 6, Rule 17 of the CPC. Lordship, for a moment, may turn to Order 6, Rule 17 of the CPC. Order 6, Rule 17 of the CPC, my lord, deals with amendment of pleadings. I read, my lord. Order 6.
Just a minute. Order 6,
Rule
Rule
17.
17.
Yes.
Yes.
It deals with the amendment of pleadings. It reads, the court may at any stage of the proceedings allow either party to alter or amend his pleadings. The word is allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendment shall be made as may be necessary for the purpose of determining the real questions and controversy between the parties. Placing reliance on this expression, the argument has been made that the pleadings in the election petition can only be amended at the behest of the election petitioner, and the returned candidate cannot file an application and seek amendment of the pleadings. Now, my lord, my answer of this particular argument is very simple. We are not seeking amendment of the pleadings. What we are seeking is striking of the pleadings under Order 16. Under Order 6, Rule 16A. I understand, my lord, the law on this is settled. I cannot seek amendment in the election petition of the election petitioner. Similarly, my lord, even in the writ proceeding, the principle of CPC is followed, and this is the practice. A respondent cannot file an application trying to amend seeking to amend the pleadings made in the writ petition. He cannot do that. He can only amend his affidavit in opposition. Likewise, a writ petitioner can amend his writ petition. Similarly, in the election petition, only the election petitioner can amend his election petition. Likewise, the respondent, my lord, can amend his written statement under Order 6, Rule 17. But when it comes to striking of the pleadings, under Order 6, Rule 16, the principle of law is entirely different. The language itself is very clear. Order 6, Rule 16 and Order 6, Rule 17, they operate in two different silos. They operate independently. It is not that, my lord, they are one cohesive whole. You mix up both the provisions. They are two separate things altogether. So, my lord, this is my answer. Now, secondly, my lord, the argument of the election petitioner is he has placed reliance on three judgments of the Supreme Court. I will refer to each of these three judgments. The first judgment is Ruplal Sathi versus Nachitar Singh Gill. That is 1982, 3 SEC 487. I hope Mr. Deori, my lord, has given my lord the list of books. My lord, this judgment may kindly be placed before your lordship. 1982, 3 SEC 487. Now, my lord, this very particular judgment does not help the election petitioner. On the contrary, it helps the case of the respondent. The relevant paragraph is paragraph 20 and 21. Lordship may kindly have a look. Where the scope of Order 6, Rule 16 has been mentioned. Para 20 and 21.
Yes.
Para 20, my lord, I read at page 499. The order passed by the High Court directing the striking out of paragraph 4 to 18 of the election petition can hardly be supported. It is not clear from the order that the High Court proceeded to act under Order 7, Rule 11A or under Order 6, Rule 16 of the court in passing the order that it did. So, my lord, there was no clarity. I hope I am audible or not, I don't know. There is some disruption in the link. Am I audible?
Yes, you're
Very
audible.
well, because I can't see my lord. If my lord is hearing me, my lord, then it is perfectly okay, because your lordship is not visible to me. I am reading
Connection,
paragraph 20.
network, audio, video,
Yes,
system
possibly.
not found.
So long as lordship can hear me,
Probably
it is perfectly okay.
there is some difficulty, but then still we can hear. You're
Yes,
audible.
yes, very well, very well. I am reading paragraph 20. The order passed by the High Court directing the striking out of paragraph 4 to 18 of the election petition can hardly be supported. It is not clear from the order that the High Court proceeded to act under Order 7, Rule 11A or under Order 6, Rule 16 of the Code in passing the order that it did. So, there was no clarity in the order of the High Court that under which provision it is exercising the power. It is rightly considered that the High Court could not have acted under Order 7, Rule 11A of the Code. Where the plaint discloses no cause of action, it is obligatory upon the court to reject the plaint as a whole under Order 7, Rule 11A of the Code. But the rule does not justify the rejection of any particular portion of a plaint. My lord, there is no quarrel with this proposition of law. Because, my lord, if the no cause of action has arisen, then, my lord, I would file an application under Order 7, Rule 11 of the CPC for the rejection of the plaint itself. But, my lord, when I am seeking striking of the pleadings in the petition, then, my lord, the right source of power is Order 6, Rule 16. Mullah's Civil Procedure Code, 13th edition, Volume 1, page 755, that law has been discussed. It is therefore necessary to consider whether the order passed by the High Court could be justified under Order 6, Rule 16 of the Code, which reads as follows. Then, my lord, Order 6, Rule 16, my lord, has been quoted over here. Then comes the paragraph 21. The order passed by the High Court directing that paragraph 4 to 18 of the election petition be struck out cannot be sustained on the terms of Order 6, Rule 16 of the Code. There is no finding reached by the High Court that the averments in paragraph 4 to 18 of the election petition are either unnecessary, frivolous, or vexatious, or that they are such as may be tend to prejudice, embarrass, or delay the fair trial of the election. Nor is there any finding that the averments therein are such as to continue an abuse of the process of the court. That being so, the High Court had no power to direct the striking out of paragraph 4 to 18 of the election petition. My lord, I have no quarrel with the principle of law stated herein. My entire case is that the very pleadings I have referred to from the election petition, those very pleadings are unnecessary and frivolous because of the nature of case projected and because of striking of the issues by the election petitioner himself. It is the case of election petitioner that is no longer relying on the issue of booth capturing, poll rigging, etc., and malpractices connected therewith. And on the basis thereof, my lord, the two issues were deleted, issue number 7 and 9, and the issues were recasted. Our entire case is on the deletion of the two issues, 7 and 9, and after clear-cut statement by the election petitioner that he is no longer relying on the allegations of malpractices pertaining to booth capturing and the poll rigging, my lord, the pleadings connected therewith are unnecessary and frivolous, and therefore liable to be struck off. The next case, my lord, relied on by the election petitioner is KK Modi versus KN Modi. That is, the citation is 1998, 3 SCC, page 573. Now, my lord, this judgment also does not help the election petitioner. This judgment, my lord, has no relevance in the present case because this is an authority on Order 6, Rule 16C, not an authority on Order 6, Rule 16A. 16C, my lord, talks of which is otherwise an abuse of the process of the court. Those very pleadings which are an abuse of the process of the court should be struck off. Now, my lord, the entire case is on Order 6, Rule 16C and not Order 6, Rule 16A. For this, Lordship may see kindly two paragraphs. I refer to paragraph 42 of the judgment, 98.3 SEC.
Para?
Para 42 may kindly be seen first.
N?
Yes, paragraph 42, below.
Okay.
My lord, I read para 42. Under Order 6, Rule 16, the court may at any stage of the proceeding order to be struck out inter alia any matter in any pleading which is otherwise an abuse of the process of the court. That is C, my lord, not A and B. Mullah in his treatise on the Code of Civil Procedure, 15th edition, has stated that power under clause C of Order 6, Rule 16 of the Code is confined to cases where the abuse of the process of the court is manifest from the pleadings, and that this power is unlike the power under section 151, whereunder courts have inherent power to strike out pleadings or to stay or dismiss proceedings which are an abuse of their process. In the present case, the High Court has held the suit to be an abuse of the process of the court on the basis of what is stated in the plaint. My lord, that is not our case. Then, my lord, in para 43, my lord, this abuse of the process, what is the meaning thereof, etc., has been explained. My lord, the entire judgment is on that very proposition and principle. It has no application whatsoever in the facts and circumstances of the present case, where we are relying on Order 6, Rule 16A, frivolous and unnecessary. Likewise, my lord, the next case, my lord, which has been relied on by the election petitioner is Azhar Hussain versus Rajiv Gandhi. That is 1986. Supplementary SEC 315. Now, my lord, again, so far as Azhar Hussain case is concerned, my lord, I have checked in. This Azhar Hussain case, my lord, again deals with Order 7, Rule 11 of the CPC for non-disclosure of cause of action. In the case of Azhar Hussain, the application was made under Order 7, Rule 11 of the CPC, and it was argued that the election petition does not disclose a cause of action. Now, my lord, if the entire argument is based on non-existence of the cause of action, the appropriate proceeding has to be under Order 7, Rule 11 of the CPC, not under Order 6, Rule 16 for striking of the pleadings. In this connection, my lord, only 3 paragraphs can be seen, and it will be very clear. Paragraph 1, 8, and 9 of the Azhar Hussain case. Paragraph 1. The very recital itself, the court is started. I read below.
Yes. Yes.
At page 318, an election petition having been dismissed on the ground that it did not comply with the mandatory requirement to furnish material facts and particulars enjoined by Section 83 of the Representation of People Act, and that it did not disclose a cause of action, the election petitioner has appealed to this court under Section 116A of the Representation of People Act, such and such. So, below, on dismissal of the election petition under Order 7, Rule 11, for not disclosing a cause of action, they approach the Supreme Court. Para 8, for that matter. Para 8.
That is yes.
Page 322. The argument is that as much as Section 83, subsection 1 is not adverted to in Section 86 in the context of the provisions, non-compliance with which entails the dismissal of the election petition, it follows that non-compliance with the requirement of Section 83(1), even though mandatory, do not have lethal consequences of dismissal. Now, it is not disputed that the Code of Civil Procedure applies to the trial of an election petition by virtue of Section 87 of the Act. Since CPC is applicable, the court trying the election petition can act in exercise of the powers of the Code, including Order 6, Rule 16, and Order 7, Rule 11A, which reads thus. So, my lord, order 7 rule 11. Because what happens is, my lord, lordship may recall in the Representation of People's Act, I will explain this. In the Representation of People's Act, for a moment, lordship may see section 86 of the act. Section 86 of the Representation of People's Act, 1951.
Yes.
The High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or Section 82 or Section 117. Section 117 we will leave, my lord, for a moment. Section 81 or Section 82, if there is a non-compliance, Section 86 says the election petition is liable to be dismissed if it doesn't comply with 81 or 82. Now, what is 81? 81 deals with the presentation of election petition within 45 days. And the procedural part, my lord, has been dealt with in Section 81. Section 82, my lord, are the parties to the election petition. What are the parties? So if these two provisions are violated, Section 86 mandates election petition is liable to be dismissed. Now, my lord, there is no reference of Section 83 in Section 86. Now, what does 83 say? 83 says an election petition shall contain a concise statement of the material facts on which petitioner relies, shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties, such and such, shall be signed by the petitioner and verified in the manner laid down, etc. So, my lord, 7 substance of Section 83 is, it shall contain a concise statement of material facts on which the petitioner relies. Now, my lord, the argument before the Supreme Court was that, look, Section 86 doesn't talk about the non-compliance of Section 83. So if there is a non-compliance of Section 83, therefore, election petition cannot be dismissed. Election petition can only be dismissed if there is non-compliance with Section 81 and Section 82, as per the mandate of 86. Then Supreme Court answered this question by saying, even though 83 has not been mentioned, Order 7 Rule 11 is always there. Because if concise statement of material facts are not there, that means cause of action has not been disclosed. On non-disclosure of a cause of action, or non-disclosure of the statement of material facts, Order 7 Rule 11 application would lie. You know, I just do not understand how the Azhar Hussain case would help the election petitioner in the facts and circumstances of the present case. Supreme Court said either you go for striking of the pleadings if the paragraphs are not relevant, or you go for Order 7 Rule 11. The argument that merely because 83 has not been mentioned in Section 86 would not hold any water, because CPC applies as per the mandate of Section 87 of the Representation of People's Act. So, my lord, on the basis, my lord, in view of all this, my submission is, my lord, that paragraph, my lord, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27, these paragraphs, my lord, are liable to be struck off on the ground. These paragraphs, number 1, are unnecessary and frivolous. And number 2, even the election petitioner in his IA 292 of 2025 has categorically stated that he is no longer relying on the allegations of malpractices pertaining to booth capturing and poll rigging. And these paragraphs, my lord, deal only with those allegations of malpractices pertaining to poll rigging and the booth capturing. So therefore, my lord, the pleadings made in these paragraphs have been rendered wholly unnecessary and frivolous, and therefore liable to be struck off in view of the mandate of Order 6, Rule 16A of the CPC. And secondly, my lord, the pleadings made in Para 6.2.1 and Para 6.2.2 deal with non-disclosure of a particular property, landed property at Jolung village. Allegation is in the pleading that this property was not disclosed by the returned candidate. Now, my lord, prima facie I have shown in the Form 26 itself that this very particular landed property has been disclosed. When the landed property has been disclosed, my lord, the allegation doesn't hold any water, prima facie. So therefore, my lord, the pleadings made in connection therewith has been rendered totally unnecessary and therefore frivolous. And therefore, my lord, these two paragraphs may also kindly be struck off. That's, my lord, my submission. Subject to, my lord, whatever the election petitioner may argue, my lord, I may give a reply if necessary. And, my lord, after striking off these pleadings, they can file, my lord, the fresh election petition.
Yes, Mr. Singh.
May I please, my lord?
Yes.
But my learned senior friend has argued in detail. And as mentioned about certain paragraphs, my lord, before I go to the merit of the case, I would like to summon, my lord. So for these matters are concerned, in many stages of the proceedings, they have filed certain IAs, even challenging the very application. That's not matter, that was rejected. Now, so far Order 7 Rule 11 is concerned, Order 7 Rule 11 was filed. That was rejected. It went up to Supreme Court. Honorable Supreme Court upheld the order passed by this Honorable High Court. Now, in that particular, in Order 7 Rule 11, it was held that there was a cause of action. Even so far, boot rigging and boot capturing is concerned. Thereafter, there was a lengthy argument on the framing of issues, even on the boot capturing, about the non-disclosure of immobile properties. Then ultimately, because as Melody is well aware of the fact that the election petition is a time-bound, it has to be concluded in time-bound manner. So what we have decided that for a speedy trial of this particular election petition, so we decided, even though the course of action was there, even the issues were framed, we decided to drop this boot capturing, boot rigging, because it may take lots of time, even a year. So we have decided to expedite the matter. That is only for the speedy trial, not because of the fact that it is a frivolous or vexatious. Not on the ground that no course of action arises for this particular matter, because there was a course of action and issue was framed. Issue number 7 and 9 was regarding boot capturing and boot rigging. So we decided to drop because there are other issues which you can prove. Even with the issues, we can even still win the election petition. So in order to expedite the matter, we have dropped this, not on the ground that this is frivolous or this is vexatious or it is unnecessary. So in Order 6, Rule 16, when these particular pleadings are to be struck off, when it is vexatious, it's scandalous, and when it is unnecessary. When in the light of the fact that Order 7, Rule 11 was even upheld, the rejection of that was upheld by the Honorable Supreme Court. How can we call this vexatious, unnecessary, and scandalous? Only if your lordship finds that is scandalous and vexatious. And moreover, in their miscase number 315, even they have not given a specific pleading that this is scandalous or vexatious.
On the scandalous.
Yeah, there's no specific pleading that this is scandalous or vexatious. The only thing that they have to strike off. Now, my lord, we are at this juncture because we are at a stage of exhibiting the documents. Now they say it's scandalous, even in their written statement. While filing even a written statement, they have not even stated that this is scandalous and vexatious. By going to the statement made in the written statement, my lord would not even find a single pleading that this pleading of boot rigging they have denied, but not to the extent that this is scandalous, vexatious, and unnecessary. Now, when after they have filed a written statement, now they have come at the stage of the evidence that these are scandalous, vexatious. They ought to have taken this point. We only drop it.
Subsequently, by filing IA,
My lord,
pray for deletion of issue number 7 and 8.
and 8.
7 and 9.
There was agreed between the parties that we drop.
Yes, yes. And
Just not on the ground that this vexation.
after deletion of that two issues,
Where
then this,
and
idea.
it was reframed and two issues were deleted.
Yes, yes.
Just because we didn't want to pursue that. Only to expedite the matter.
So now what they're saying is if you don't want to pursue with that issues.
No, we're not.
then these are unnecessary.
No, my lord, this unnecessary has got a connection which is vexatious and scandalous. Unnecessary.
He's not pressing for scandalous.
No, he says there is vexatious and scandalous. That is India.
No, probably he specifically says that
The submission was made by my learned senior. That is vexatious. I noted.
Yes, vexatious.
I noted
used
that. I
only
noted
two
that.
words. Let me repeat. I have
Two
used
words.
only
He has
two
used
words.
two words.
Unnecessary and
Unnecessary and frivolous.
That's all.
Now,
Not the scandalous. He made it clear
now,
in the
now
very beginning.
this particular, so far boot rigging and boot capturing is concerned, my lord, even we are not leading evidence to that extent. And we have confined ourselves to PW2 only. We are not even leading evidence. This is nothing but to delay the trial. If even after this is deleted and if we lead evidence, if we adduce evidence, my lord, in that case, there's one thing. Now, so we're not leading evidence. Now, thereafter, there will be strike off, there will be amended, this thing will be just only to delay because we're not leading any evidence. And they also agree that this is not from where the question of unnecessary will come. Because this unnecessary, even though this pleading remains, is we are not leading. So when the unnecessary, if that unnecessary is going to cause prejudice to them, that's a different thing. This will remain as a silent. Even issue has been deleted. This will only delay the trial. And this has been done only to delay the trial. That is my in a preliminary objection before I go to the matter. Number two, what my learned senior has said to delete two paragraphs, that is paragraph 6.2 and 6.21, referring to page 1110 of the election petition, where they said that they have disclosed the particular property in Jolang. Now, the dispute is that in issue number 3 that was framed by this honorable court, that even the non-disclosure immovable property is there. And this was argued in detail about this non-disclosure of this particular property at the time of framing of issues, and this is issue number 3. Now the question is, my lord, they have said that this particular they have disclosed. Now, at disclosing a property will not. Because they said that this is an inherited property, and in the documents which you have submitted, which will be exhibited now, they said that it is an allotted property. So, my lord, so for the state of Arunachal is concerned, your lordship knows better. He said this is inherited property. My lord, I respectfully take my lord to page 110 of the nomination paper. In the last 2 paragraphs column, he said that yes, this is an inherited property. But in others document, he said this is an allotted property. So now, about the nature of the property is also to be known, because there are a lot of things so far this property is concerned. Therefore, especially they don't want to bring this property in dispute. I'll be out of track if I submit all this at this present, because there are CRP pending. So for this property is concerned, this property was mortgaged to Apex Bank. So this property was there, this property was not there. Warrant was issued against him. There are a lot of things over this property is concerned. So they are shying away from this particular property. Here he says it's inherited property. So these are a question of trial. These are a question of trial, my lord. So for boot rigging and boot capturing concern, my lord, as we have filed a petition to delete this particular issues, that's up to that extent, my lord. I agree, my lord, because so far our application concern will drop so far anything that is concerned with boot rigging and boot capturing. But the correct practice in election petition doesn't only fall within that particular thing of boot capturing. It also falls for non-disclosure, for undue influence to the voters. This all amounts to corrupt practice. This all amount to corrupt practice, not actually the boot capturing so far boot rigging and boot capturing is concerned. Apart from that, there are a lot of things which even, my lord, my learned senior also quite aware of the fact that certain things may amount to undue influence, where even my lord may not even require to file Form 25. Automatically, it amounts to corrupt practice. Maybe they may not be liable under whatever section 120 to 125. That is a different thing. So my only humble submission is, so for this particular misapplication concern, well, so for the paragraphs about the boot capturing, boot rigging is concerned, even though it is not deleted, we are not going to lead any evidence, and it will be just because again we have to amend the entire election petition. So we will not, as we have dropped, as we have filed to delete these issues has been dropped. We are not leading anything, any evidence so far boot capturing, boot rigging is concerned. We'll confine to the renumbered issues framed by my lord. And so far, paragraph 6.221 and 6.22, so far the property in Jalon is concerned, there are wrong information so far this property is concerned. He said that this is inherited. Then this is not inherited. So he has not disclosed this property in a true form. And so far, whether this is inherited or allotted will come only at the stage of trial, not on the statement made by the respondent number 1. My lord, I respectfully take my lord to page 1110. And the pleadings made therein. That has to be read with page 27 that I have given in para 6.21. My lord, first I take my lord to page 27 before I take my lord to page 1110.
Yes.
My lord, the specific abutments made by the election petitioner is that the petitioner begs to that the respondent has not disclosed a plot of so-and-so in the form 20 while filing his nomination. The area so-and-so at Julang, which was allotted to him by land holding certificate number so-and-so. Very specific. Has not been disclosed. Now, my lord, I respectfully take my lord to page 1110. Now, my lord. And property valuation is also not given. I don't know why, in fact, they are quite afraid of this particular property and they say it has been disclosed. This is nothing but misleading the court. Even after they have failed in Order 7, Rule 11 about this property. And in Order 7, Rule 11, the court has held that this particular, that it is a question of trial. And still they are misleading that they have disclosed this particular property. So it's nothing but like throwing IAS after IAS is only to delay the matter, my lord. Therefore, even without striking of the pleadings on the ground of unnecessity, it can still remain. We can go ahead with the exhibition because we are not leading any evidence. We are not leading any evidence.
But since they have filed this IA, so we need to dispose of the IA.
No, my lord. But 6.2, 6.21, paragraph 8, and all this. So, my lord, with an undertaking.
This according to you, this will remain.
It should remain, we will not lead any evidence.
Okay,
On
but then what about this 18, 19, 20, 21, 24, 25, 26, and 27? This all.
It is on boot rigging and boot capturing.
Yes, yes. It all connected. These all paragraphs are connected with.
They said it. We didn't even without striking off, even without striking, because why? When it is unnecessary, because when these particular pleadings may delay the trial, because it becomes unnecessary. But this, by remaining this, we undertake that we will not lead any evidence. So unnecessary occasion only when that is going to cause prejudice and delay the trial. This particular, we have only submitted our IA to strike off this only to expedite the trial. So the objective is very different. So by remaining this, we can still proceed with the evidence.
We need to be very clear about the issues.
Yeah, but so far the boot rigging and boot capturing is concerned, I submit before my lord that we will not lead any evidence to the extent of boot rigging and boot capturing.
And you want to record that?
My lord, it may be recorded.
Okay.
We will not. So because that's unnecessary doesn't happen.
So that way we'll dispose of this.
My lord, it can be disposed of in that manner, and it can
in that manner.
and we can go
So
ahead
this,
with the
this then paragraph 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27 goes.
It may
Okay.
remain, but we will not lead any evidence so far. This
It will remain. Is it possible that it will remain? And since they have undertaken now not to lead any evidence on that.
my lord, will not lead any evidence.
I'll answer. May I, if my learned friend is continuing, my lord,
Then
I
in-
should not interrupt him. If he's
No,
finished his
so
argument,
he has
then
an
I can
objection
clarify.
on paragraph 6.2.1 and 6.2.2. But then with regards to the paragraph above 18 to 27, so that.
May I
Yes,
clarify?
please.
May I clarify?
Yes.
Very
Yes, please.
My lord, position is like this. First of all, let me clarify first part. My learned friend has repeatedly argued as to how are we prejudiced, as to how the returned candidate is prejudiced by the presence of these very pleadings in the election petition, when he has made it very clear that he is not leading any evidence on these pleadings, that these pleadings do not form any further the part of the issues. Answer is simple, my lord. The law is very clear. Let us again see Order 6, Rule 16. I read again. A says, which may be unnecessary, comma, scandalous, comma, frivolous, or vexatious, or is disjunctive. It is not conjunctive. Then this is again followed by or, disjunctive. So, my lord, each A, B, and C, they exist independent of other. A is independent of B, B is independent of C, and vexatious and frivolous are independent of each other. So in A, unnecessary, comma, scandalous, comma, frivolous, or vexatious. Then again or. B, which may tend to prejudice, embarrass, or delay. So, my lord, prejudice, embarrass, or delay is independent by itself. It is dead. It is preceded, it is followed by disjunctive or. Disjunctive or, which is used at the end of Order 6, Rule 16A. That is my first answer. The second answer is, my lord, what is the meaning of unnecessary and frivolous? A pleading may not be unnecessary in the beginning, but it may be rendered unnecessary by the conduct of the election petitioner. The moment election petitioner filed interlocutory application and made a submission before the court, he does not want to press these very pleadings, that issues which has been framed on the basis of those pleadings may be deleted, and he would not lead any evidence. These very pleadings became unnecessary. Even if, my lord, lordship may allow him not to retype the election petition, but a declaration from the honorable court would be necessary that the pleadings in para 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27 would be treated to be struck off from the election petition. No fresh petition may be filed.
Fair
but
enough.
a declaration,
Fair enough.
declaration
One
of the honorable court has to be there.
Small IA saying that this paragraph 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27 be treated to be struck off.
Yes,
Struck off.
maybe struck off. Yes,
my lord,
maybe struck
my lord,
off.
my humble
clarify.
Without amending the election
Yes.
petition.
Yes, even the declaration of the honorable court would suffice the purpose.
No
First
need to
part.
file an amended election
They may
petition.
not do it. They may not do it. Declaration
Which,
is
according
that
to
we
you,
will
will
be
take
clear.
time.
These pleadings
That
are
is
no
likely
longer
to
the
take
part of the election petition any further.
my lord,
That is
my lord,
number one. Let me clarify, sir. Since my lord has asked me a
Yes, sir.
question, I'll complete
Yes.
my part. Now, my lord, the second part. The second part pertains to the particular property. My learned friend has raised an issue pertaining to the nature of property. It is inherited or it is self-owned, etc., etc. My lord, so far as the mandate of law is concerned, it is the disclosure or non-disclosure of the property. That is the only issue. Whether a particular property which is in possession of the returned candidate, whether he has disclosed it or he has not disclosed it. If there is a disclosure in the Form 26 affidavit, and it is not doubted that it is not that very particular property, then the nature of the property is insignificant. How does it matter whether it is created by me or it is inherited by me? So long as I am in the control of the property, so long as the property belongs to me and I'm claiming it belongs to me and I'm showing it in my Form 26 affidavit, the property has been disclosed. Unless and until the election petitioner doubts that it is not that very particular property of Jolung village which he has mentioned, it is some other property in Jolung village, then I can concede. He is not saying that. He is saying what is the nature of this property? It is not very clear. Nature of the property is immaterial. The question is whether we have disclosed it or we have not disclosed it. If you concede we have disclosed it, then the paragraph 6.2.1 and 6.2.2 will have to go. It have to be struck off. Otherwise, if he says that he is doubting that it is that very particular property, therefore the paragraph should remain, and he will need evidence to demonstrate that it is this is not a particular property of Jolung village which he has mentioned, which is 1,53,000 square feet. I will concede that. Let the paragraph remain in that case. But he is not saying so.
Lord, the issue has already been framed so far. This particular property is concerned. Now, so far the disclosure property is concerned. Even my learned senior knows well of the fact that in Form 26, how the property has to be disclosed. The actual value of the property, how that has been acquired, from whom that, because we have to know the nature of the property. So they're silent on that. Even that is called non-disclosure. Where they say, I have disclosed, I belong. Well, can it be go in that general way that I have got so much property in Arunachal, I'm disclosing all my property? It cannot be. Because why that tabulation is being given? Is it inherent?
This application under Order 6, Rule 16 and 17 of the Code of Civil Procedure 1908 has been filed, seeking struck off out of pleading of the election petition. Of the paragraph, 17 to 30 of the election petition. I'll take the point. Okay.
Very good.
Correct. And then
And my lord may forgive me because Mr. Deori is already
yes.
there for execution of document will in my presence may be dispensed
No
with.
problem. No problem. Okay. It is para. The Learned Counsel for the applicant submits that the opposite party stroke election petitioner file application under Order 14, Rule 5, read with Section 151 of CPC, being IA number 292 stroke 2025. Allowing the applicant stroke election petition not to press the issue number 7 and 9 relating to vote capturing inter alia, stating that continuation of issue number 7 and 9 no longer necessary for complete and effective adjudication of the controversies between the parties. And their consideration would only lead to unnecessary enlargement, the scope of trial, causing unavoidable delay. Stop. Accordingly, the application was allowed.
My lord, only one very small clarification, my lord, may I give? It has been
Yes.
brought to my notice, one very small clarification, my lord. It has been brought to my notice that in his examination in chief, the election petitioner in para 24 onwards has given evidence on booth capturing. So, my lord, I would take it that my election petitioner would not also be pressing that very particular portion of examination in chief on booth capturing.
My lord, subject to, my lord, if my learned senior permits me, my lord, while filing the documents, my lord, we have, because it was filed long time back, even 5-6 months back, about the list of documents. So that time we have filed all the relevant things so far the booth capturing is concerned. So what my learned friend was telling to me that we'll have to drop this. We'll drop it. We'll drop it, we undertake. So the best suggestion was given by learned friend. So the matter can be fixed day after tomorrow. In the meantime, we'll file the IA and we'll also drop, because we have to find what are the documents to be dropped. So it can be fixed day after tomorrow. So,
So then we'll do that. Day after tomorrow.
we'll file the IA and we'll go for the examination. Because
Mr. Deori is there.
my learned friend.
Okay, today this order will be passed, then.
It will be difficult for me.
No, it's just only for exhibition of documents.
Only for exhibition.
That is our.
Because I thought that exhibition will take around 45 minutes at the most.
At the most.
Hmm.
So we will do exhibition day after tomorrow on 7. Then next day, my learned friend Deori can cross, or my learned senior can cross.
No, cross is not possible. I have to come physically for that. I can't do it before
That's
VC.
what
in
you.
VC.
No, only
Sir, if you
only
do the cross.
examination on chip and the exhibition of the document will be
Only that.
of course
Cross
done
cannot be
after
done
tomorrow,
through
and
VC.
then for cross you can come.
Cross
So
I have
cross
to
will
come
take time and
physically, my
come.
lord. I'll take a
Yes,
date
yes.
for that. Physically, I will have to come.
Yes. That will be done.
Well, let it be on 8 then.
8.
Yes. He will be.
Because I'll be not here in 7, Your Honor. Because I'm going
So
outside.
let us fix it on 7. It's always better.
Nobody will be here.
He will present, man. I'm going to.
Even I'm going
Because
On 8, man.
it's only our duty.
on 8, Your Honor.
Only for exhibition only. Exhibition, because you need to be present to show the document, to clarify the document, and then the name of the document probably. Okay. No, only their exhibition, because cross you will be given an opportunity, and then if there is any objection, just raise and we'll just record it. The objection only.
It can be then 9. We can go for cross.
Or next day 9 or any thereafter. Cross after that, I think probably 9 will be difficult because 9
My
will
lord,
be the
because
last
in my
day.
case, my lord, let me explain my medical condition. The difficulty was I was hospitalized for UTI, because in my case, considering the age, prostate
Okay,
issues are
so
there.
we'll
So
fix
day after
we'll
tomorrow,
fix
my lord,
after
my culture
six.
and test will be
Wait.
done. So I'll give a date.
For
Let me
cross
look
we'll
into
fix after
everything.
that.
I will give a date.
After tomorrow we'll fix. We are fixing it on 8
Yes, 8.
or 7.
No, 8, Your Lordship. 8.
7 I think will be better because the court also get one holiday on.
It's up to them, those who are present there.
Yes, madam.
Because you just one of you just to be present to be present to raise if there is an objection.
I have seen their, my lord, exhibits. It is all photocopy, my lord. It's certified to be. There is.
That is why we'll just record. Originally there because that will be compared. That will be compared. So you only to see if there is a original is being produced compared.
There is a certified copy, not the original copy. Is not there, my lord.
No, they will produce if there is.
It will be recorded only.
No, that at the time of exhibition.
On that day,
Yes.
for comparison, probably they will produce the original. Okay.
Because so far many are public. Now,
And then this,
official document,
okay,
we have to
this
only
IA
officially
dispose of, okay, IA dispose of, pass order.
Yes.
In the way,
Yes, copy lena.
and in the last, it will say that you will file one IA declaring, since you have undertaken, declaring that you will not press for this paragraph 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27. Okay. And then we are dropping the 6.2.1 and 6.2.2. Okay. Hmm. Okay, Mr. M.G. Singh, Learning Council for the Election Petitioner is present. Also, Mr. Tiwari, Learning Senior Counsel, assisted by Ms. K. Deori, Learning Council for the respondent number 1 are present, huh? Is present, huh? Staff, huh? Mr. Singh, on that day, so you file IA on 7th.
I'll file.
Okay, IA
on-
is
on
another
the day,
taken. Okay. So because then it will be clear, it will be clarified. Okay.
Yeah, they will file on 7, my lord. Matter may be listed on 8 because tomorrow to holiday. Yes.
If the record comes,
Okay, in view of the order pass today in IAC 315 AP 2025, the election petitioner shall file necessary file IA by 7/1/2025 staff para as agreed upon by both the Learning Council for parties. List the matter again on. Will list it on 7 also and then 8 also. Okay, 7.
and if
Since he's
something
filing on
happens,
7th,
because
it can only be listed on 8th below. Since he's
Okay,
filing on
okay, list
7th,
it on again on 8 along with on 8, huh? Along with the IF.
may humble submission.
Oh.
Suppose if the matter is listed, because they have nothing to do with, if the matter is listed on 7, if we file the IM morning, and if the record doesn't come, it can be posted next day also. Or I leave it to the wisdom of my lord.
8th is better. Mr. Deori will
8,
be present.
okay. Let the matter on 8, huh? You file by 7, okay? List it on 8 for exhibition of the document of the election petitioner. Okay? Okay.
Obliged, my lord.
Send this, huh? Entire, otherwise. Just a minute, huh?
इसको ले जाना कहीं.
Okay. Okay. This one.
Item number 14.
Yes.
Your Lordship,
Yes.
may I draw your kind attention
Yes, sir.
to our earlier order dated 23/12/2025, prayed for exhibition of documents, my lord.
Okay. Main petition. Earlier main petition. There was one not. Earlier main petition. Earlier one. Oh, this is. No, not this one. Earlier one. Item 12 main petition. Bring the main petition. Okay. It's okay. 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 Tabular form is there. Take it. Mm. Yes. So, yes. Have you come prepared with in the tabular form?
This is my lord compiled.
Where is evidence in the affidavit? Evidence in affidavit?
आना पड़ेगा
नहीं नहीं
जिनको तो सील मानना पड़ेगा
पहले कोर्ट को देखा कोर्ट में
Of the PW1.
ये नहीं होता
Deposition. Mhm. Evidence in the form of it, yes. How many pages of your evidence?
Altogether, my lord, 140 pages.
No, no, only your evidence in affidavit.
My evidence.
Huh? Evidence of the election petition in affidavit, affidavit in the person. What is this? Why you have said that evidence of the election petition in the form of affidavit, stroke affidavit in opposition? Why it is? How it is affidavit in opposition?
This was filed, my lord, in In connection to IA, I think.
Hmm? No,
It's
election
evident.
petition number 2.
Yes. It should be evidence on sheep, not on affidavit in opinion.
Yes, it's evidence in chief only.
Yes.
Examination in chief. Which one is your evidence? Will you please show me?
Evidence of election petitioners.
Your affidavit in evidence is to be treated as examination in chief. Where is that?
Already filed, my lord.
Where? Please.
This is the one he's with, my lord.
उनको दिखाने के लिए.
Affidavit in opposition.
Affidavit in opposition.
Oh, yeah, yeah.
My lord, this is an evidently error, so it may be corrected. my lord.
Oh, that will be difficult.
File fresh, my lord. This one.
Unless you file fresh, it will be.
Earlier also, this was not, my lord, there was no any objection of this.
No, this was filed at the time of IA, my lord. When we have filed an IA under Order 7, Rule 11, at that time it was filed. That time we said that then the court said, no, this is considered at that time.
They have not raised any objection during that time. They have
No.
filed an IA.
Now today it will be exhibited.
That stage has come today, that's why.
But they have filed an IA which was disposed of. In that reply, this was filed, my lord.
Yes.
In that reply, the IA.
In connection to IA.
IA. Not this is not the evidence.
This is not an evidence.
Oh.
They have but they have filed.
See,
IA.
I think unless you.
Let him file a fresh.
They have filed, my lord, this IA.
That was disposed of long before.
Oh, it will be very, very difficult.
Here they have objected my documents. Here they have objected my
See,
documents.
we have no doubt about your knowledge, about your experience, everything.
My lord.
But then you see, court needs a proper assistance. Proper assistance. I have been, of course, telling you since inception when I took over that it's always better to engage one at Atlantic Council. You also be there if you doubt.
Yes, my lord.
But-
Kindly see his source of income, my lord.
This will
More than 8 years, car, property, everything. He can engage a lawyer. He has source of income also.
My lord, this is a very highly sensitive case for me.
That is why.
That's why I'm pleading.
That is why you be there. You also be there. You assist there. But then someone has to be there. Whether this, see this one, where is the evidence now? You just tell me.
Evidence.
Today it is fixed for exhibition of the evidence, and you have filed in affidavit form. That is to be treated as examination chief. And then today, the documents are to be exhibited. And then where is that?
Oh. I thought, my lord, this will do. And
You don't think.
There's no direction for me to.
We only want
Yeah.
that it should be the correct one. We proceed with the correct procedure. Why don't you engage somebody? The advocates are ready. Only few fees will go, nothing else. and then you don't want to part with,
Oh.
and then you are taking risk of your case, and then troubling the court also. Court needs proper assistance because there are a lot of documents. They need, you have to show the document. I'll be throwing the file before you to show. You have to show it. Don't waste the court's time also.
My lord, this cannot be treated as evidence of this case.
How can it be treated as, if it is not evidence, if you have not written?
I thought this will my petition, though.
You write affidavit in opposition. Can I treat it as evidence in evidence? Affidavit in evidence, treat it as examination in chief. You said affidavit in opposition. How can that be treated? You said black. Can I treat it as a white?
The court officer can also suggest me that way, but
Why he's opposite party? He's your enemy.
my lord,
How can you expect?
may I plead, my lord, give me some time for filing of this.
See, you will be wasting time.
On 7th, my lord, I will file it.
Mr. Singh, could you just kindly assist him, suggest him something if you have heard, and if there is something difficulty, and then see, he seriously needs some assistance, and tell him that unless he gets an assistance from any the legal counsel, it will be difficult. Suggest that part.
He showed me these documents and I said, it's very good. You have filed a very good documents, list of document. But so far the evidence in examination chief is concerned, I have not gone through, but he has filed a very good compilation document.
Document compilation, I have.
Now I have come to know that he has not filed examination. He has not filed examination. That is a 4 pages. Like I'll just.
I will find it.
No. See,
That I was not aware of that.
What I will suggest, of course, it's not my part.
Yeah.
Just
My lord.
as because I have been seeing you appearing, I have no doubt about your knowledge, experience, and everything. And then you see, and then since he is also appearing in other case, we are fixing both the election petition on the same day. Why don't you just share some of your fees? Minimum fee.
I'll help him pro bono, my lord. I'll help him pro bono.
My lord, I was not aware of that things.
No. What I'm suggesting him to engage somebody, anyone, not necessarily Mr. Singh.
Earlier,
Anyone.
My inability that I have already expressed, my lord. This is highly sensitive case for me. So
Anyone, you're trusted person. You can engage anyone.
Part, not the merit part.
Okay.
Only the procedural part.
This is sensitive case. That is why I'm saying. That you need some assistance for you only. Otherwise, you see, outright rejection, all those things.
For the procedural aspect. Only the procedure.
For the procedural aspect, you know, but then for the procedural aspect, you need some assistance.
You need one more. You have not shown me, no? You need one evidence.
Evidence
No, that is wrong.
That is wrong.
So see, this way it will be a wastage of time. And then we thought that the other cases, because
Procedural aspect, I'll assess. Procedural aspect, not the merit.
I beg pardon, my lord. There is some procedural lapses. On 7th, I will file it, my lord.
okay, Mr. N. Johnson, sir, petitioner in person. Submits that inadvertently. He has mentioned, where is the petition? It's here. Okay, it's fine, okay. Huh? No. Evidence in affidavit. Okay. Where? This. Okay. Instead of marking as evidence, affidavit in evidence of the election petitioner, he has marked Affidavit, he has marked affidavit in opposition. Therefore, press for some time to correct and amend the same by filing appropriate IA. Will allow?
Yes.
Okay. The prayer so made by the petitioner in person has not been objected to by the Land Council for the respondent. Accordingly, the prayer is allowed. List is matter.
7, my lord.
7?
No,
Yeah,
on 8, my lord.
on 8.
Let him file 7.
Okay, you file. Okay, you file on 7. It will be listed on 8. Okay.
Tomorrow
If you file on 7, it will not come again.
Oh, my lord, yeah.
You file on 7th, it will be listed on 8.
Highly obliged, much obliged, my lord.
Just on it, huh? 8. Okay. Okay. नहीं तो नोट्स को इसको यहीं रखना मारना नोट्स को यहीं दे लो हाँ ओके फिनिश ना पता नहीं ये बहुत सी बार है क्या हाँ है
इलेक्शन पिटीशन का वो बाइंडिंग वाला स्लिप चाहिए बोला इलेक्शन पिटीशन
बाद में इसको मांगना है बोले यही
नहीं संतोष जी सिर्फ बाइंडिंग चाहिए बोला
नहीं तो बाद में उधर इधर हो जाएगा तो
बाइंडिंग सिर्फ संत होगा का धर्म लेके जाएगा परसों लेके कौन सा वाला हाँ दोनों
क्या चाहिए?
बाइंडिंग जो करके रखा है राहुल कर
ये तो चैम्बर ही जाएगा ये, क्योंकि ये आपका बाइंडिंग देखे तो आपको वो है
इसको ये वाला को हाँ हाँ ये वाला को ना
और उसका है देखिए
उसका नहीं ये इस पे ही
इसका है और ये तो फाइल ही जाएगा लेकिन वो आई सी नहीं है एफसीए भी नहीं मतलब डिस्पोज करेगा देखिए हम दिख रहा है
हम तो पास तो उनका
सर